Hello, everyone. How are we? I am way early. This is not supposed to start, I don't think, until like 1:30 or 1:20. Well, I said 1:20. I wanted to be on at 1:20. But look at all you guys already in here. Good gracious alive. But what I thought we would do while we wait for all this to go down is watch some of this backstory of his previous court appearances in this same case. Let me show you guys. So we've got what he's up for in this. And of course, you'll see there's 2 felonies here. You got second degree recklessly endangering the safety, domestic abuse, and then you've also got bail jumping. Those are 2 felonies. The rest are misdemeanors. I can't remember what they dropped. I'm going to be honest with you, but these are still showing up this morning. So I don't know. We'll hear about it today. It's been so long since I've been in this case. So let's watch some of the past stuff. Let's see what you guys are seeing. I figured that you guys would want to come in early. I think I know y'all well enough. I've got the other things pulled up. I've got this court site pulled up in case we don't have a media site that's going to show it. So we've got a couple of backups here. And let's watch this while we wait for them to come on.
Brooks want to have his case calendar going forward.
After speaking with Mr. Brooks, he would like to set this for a trial, Your Honor.
Okay. Let's look for a trial and final pretrial date.
Ew, I don't like that.
Looking at the court's calendar.
Ew, I don't like that. There we go.
Mr. Corr, I don't see you have anything scheduled on July 10th. Is that because you're not available or?
No, I'm out the week before, but I'm back the 10th.
The court would have availability July 10th if that works for counsel.
That would work for me.
That's fine.
All right, July 10th for jury trial. And then let's see if we can pick a final pretrial date about a month before that.
Okay. How's June 7th at 9 o'clock?
I cannot do the 7th. I'm gone essentially from the 7th until the 20th.
Okay. How's the Monday of that week? June 5th at 9 o'clock?
That's fine.
Okay.
That worked for me.
All right. The next date will be June 5th at 9 o'clock for final pretrial.
All right.
I'm sorry, I forget. Mr. Brooks, do you want to be produced for everything? So for that date, or do you want to do that over Zoom?
I would like to do that Zoom.
Okay. Are you currently at Dodge or are you someplace else?
I'm at Dodge Stick.
All right. I'll just ask.
This is old, guys. This is old.
Normally, back in, I'm old. It used to be that people stayed there 6 weeks. I don't know what the current thing is. So I'll just ask Mr. Hampton and Mr. Rakestraw, if Mr. Brooks is moved to a different institution, if you can let us know. I'll ask my deputy court clerk today to just notify Dodge. Sometimes they can be a little prickly in like if we send them a notice today, they may send something back saying it's too far in advance. Let us know 2 or 3 weeks in advance. We'll try and stay on top of that. I'm going to ask Mr. Hampton and Mr. Rakestraw to monitor that. I don't have a permanently assigned deputy court clerk, so the young lady who's here today may not be here tomorrow. So I don't want this to fall through the cracks. All right, June 5th, 9 o'clock for final pretrial. July 10th at 9 a.m. for trial. Motions in limine, witness lists, and jury instructions. I apologize. I don't know if Mr. Corr, you'd already filed those documents.
I did.
All right. So if there's any additional defense motions, those would be due by the final pretrial date, as well as any witness list for the defense. I will require that both parties review discovery materials. In the event they believe a necessary witness for either party requires independent representation, that they make arrangements for that representation through the Office of the State Public Defender. Anything else we need to talk about this afternoon, Mr. Hampton, Rakestraw? Mr. Core?
No, thank you.
All right, Mr. Brooks, good luck to you. Try and stay safe. Try and make good decisions. We'll see you June 5th, 9 o'clock for final pretrial.
Thank you, Your Honor.
Yeah, we're good. Then I'll go to see you and I'll see you in Habits in a second.
All right, well, have a nice trip back to Madison.
I will. I've got some other stuff here. Yeah, some things.
The man convicted of killing 6 people and injuring dozens more in the Waukesha Christmas parade attack is headed back to trial, this time for crimes he's charged with in Milwaukee County. Darrell Brooks is accused of running over the mother of his children just weeks before the parade attack in November 2021. He also faces charges in Milwaukee of witness intimidation, intimidating a victim, and bail jumping. The trial is set for May. Brooks is currently serving 6 life sentences for the parade attack. And last year in Milwaukee County Court, a judge sentenced him to another 2 years behind bars after he pleaded guilty to carrying a firearm as a convicted felon in 2020 when prosecutors charged him with shooting at his own nephew.
Even after he was sentenced to life in prison for the Waukesha parade attack, Darrell Brooks has 2 new trials coming up in Milwaukee County Court.
Brooks was in 2 different courtrooms today. He has 3 pending cases in Milwaukee. 2 of the cases are related to a domestic violence incident where prosecutors say he ran over the mother of his child. That trial starts in late June. The 3rd case is from 2020. Brooks faces several charges after prosecutors say he fired a gun at someone during a fight. That trial starts in July.
Welcome in, you Brooksaholics. The Brooksaholics Anonymous Club is officially in session for its last time. Today, we close the books on a long-awaited sentencing.
Mr. Rakestraw, you don't wish to wait for Mr. Hampton?
No, we'll be okay. I spoke
right.
with Mr. Hampton. He's fine with me taking it.
Okay.
Take care of this.
State of Wisconsin versus Darrell Brooks, case number 21 CF 4596 and 21 CF 5020. Appearances, please.
Matthew Torbenson and Shelley Grosso appear for the state. Good afternoon, Your Honor.
Good afternoon.
Darrell Brooks appears by attorney William Rakestraw, who appears as co-counsel with attorney Robert Hampton, who is not here at this time, Your Honor. Good afternoon.
Good afternoon. Hi, Mr. Brooks. All right, so we are here for a status. The last time the case was in court, it was handled by Judge Feist for us. We were in the middle of a trial, and there were some movement issues. So Judge Feist handled it for us. At that time, it was set for a final pretrial. He adjourned the jury trial that was scheduled for December 12th and set it at the request of the parties for a status on today's date. Mr. Rakestraw, what can you tell me about that status and where we stand today?
Yes, Your Honor. Having spoke with Mr. Brooks, we have reached out to Attorney Torbenson to ask for a separate offer on this matter. It's my understanding Attorney Torbenson is going to get that to me forthwith. Your Honor, me and Mr. Brooks have also discussed the possibility that Mr. Brooks will possibly be asking to proceed pro se if this case goes to trial, but we can table that for the time being as we are still seeking a possible resolution. Your Honor, I would ask for ask for another status date so that we can work forward, hopefully, and obtain a resolution on this matter.
Okay, State?
Attorney Rakestraw and I discussed the parameters of an amended offer out in the hallway. I've emailed him an amended offer that involves just the 2 cases before Your Honor. I agree with the record made by Attorney Rakestraw in terms of how we proceed on this matter.
All right, just so we're clear, what I'm taking you to say is that you are looking for an offer that handles the 2 cases that are scheduled before me, separate from the case that is scheduled before Judge Feist, correct?
That is correct, Your Honor.
So not separate offers on everything?
No.
Okay. All right, so it sounds like the parties are still negotiating. Do you wish to do another status?
Yes, please.
All right. We did have an opportunity to speak before. Okay, this should be fine. We had an opportunity to speak before we called the case on the record when you first came over, Mr. Rakestraw, with Mr. Torbenson and Ms. Grasso, and you indicated that the case in Judge Feist was scheduled for a status on March 23rd.
That's correct.
It's my understanding that Mr. Brooks has requested to appear in person for each hearing, so you want him produced for that?
Yes, please.
All right, we can put it on for that same date. We have trials scheduled on March 22nd, but we'll figure it out to be able to make this happen.
Sure.
What time on the 23rd?
That was set for 1:30.
You want the same time or do you want 2 o'clock? Or,
Probably just, I mean, we should probably just do 2 o'clock, just make it easier.
And as far as that issue, the request to proceed pro se, I think that probably it sounds as if you are negotiating actively on his behalf and he's not requesting this at this point, but only if it goes to trial. So we will, I will withhold any argument or any further action on that decision at this time.
Understood, Your Honor.
the next court date is March 23rd at 2 o'clock for status.
Thank you.
All right.
Thank you. You can be seated. And could we hold just a second, please? Hold it. So folks, we're going to get started. I know emotions are running very high on this case. If you feel like you need to step out of the courtroom, please do. I'll expect everybody to conduct themselves in an orderly fashion, despite some of the allegations you're about to hear. If you feel that it's too much for you to hear, please step outside. Also, audio and visual are not allowed here via a Supreme Court order. We have one camera that's a pool camera. So that's all that we're doing here today. So please refrain from recording or videotaping this. So with that, if we could proceed. This is case number 21 CF 1848, State of Wisconsin versus Darrell Brooks. Matters tabbed to Judge Lau. Appearance by the state, please.
Good afternoon, Commissioner Sue Opper and Leslie Basie appearing for the state of Wisconsin.
Thank you. And for Mr. Brooks.
Darrell Brooks appears in person in custody with attorneys Anna Keys and Jeremy Perry. Good afternoon.
Good afternoon to you. And we are here on a criminal complaint that's now been filed. Mr. Perry, will Mr. Brooks acknowledge that he has received a copy of that complaint and will he waive its reading in open court here today?
We have received copies of the criminal complaint. We waive formal reading.
Thank you. It may at some point be relevant, but the address on the complaint is accurate.
That's right.
Thank you. And Mr. Brooks, I have reviewed a copy of this criminal complaint. I will find it does state probable cause as to each of the 5 charges before you. You're charged in count 1 with first-degree intentional homicide. That's a Class A felony, and that has a maximum possible penalty of being sentenced to imprisonment for life. That's for victim A. Count 2, first-degree intentional homicide regarding victim B, is a Class A felony. Again, the maximum possible sentence is a sentence to imprisonment for life. Count 3, first-degree intentional homicide regarding victim C is again a Class A felony, and that's punishable by a sentence to imprisonment for life. Count 4, first-degree intentional homicide regarding victim D, again, is a Class A felony. That's punishable by a sentence to imprisonment for life. Lastly, count 5, first-degree intentional homicide regarding victim E is a Class A felony. That is punishable by a sentence to imprisonment for life. As those are felonies, you're entitled to have counsel. You're entitled to have also a preliminary hearing. And I, again, have found probable cause to each of the 5 counts upon review of the pleading. So we will turn to Attorney Opper for her bail recommendation.
Thank you, sir. As to bail recommendation, Your Honor, I'd like the court to be aware of a prior criminal history as it relates to Mr. Brooks. I can advise the court he has arrest record from 3 states to include Wisconsin, Nevada, and Georgia. Starting with the state of Wisconsin, the record begins in 2000. There was a conviction in that year for substantial battery, party to a crime. A prison sentence was imposed but stayed for 3 years probation and 6 months condition time. 2002 conviction for possession of marijuana as a repeat offender, sentenced to 50 days in the House of Correction. 2003 misdemeanor conviction for resisting obstructing, sentenced to 20 days in the House of Correction. 2005, there's an arrest from Langlade County. Ultimately, he was convicted of a county ordinance violation for disorderly conduct. What's remarkable about that is that he failed to pay the fine, so he was ordered to serve 30 days in jail on the non-payment. 2009 Manitowoc County conviction for obstructing an officer, sentenced to 2 days jail time served. 2010 conviction from Wood County, Wisconsin. He was convicted of the offense of strangulation / suffocation with other charges of battery and criminal damage to property dismissed and read in. The court ordered a withheld sentence for 3 years probation. That probation was revoked, and on August 1 of 2011, he was sentenced to 11 months jail. 2012, he was convicted at the same time on 2 separate files in Milwaukee County. First file was a charge for possession of marijuana as a repeat offender, sentenced to 180 days in the House of Correction. The second file, he was convicted of misdemeanor bail jumping and misdemeanor possession of THC, also sentenced to 180 days in the House of Correction, concurrent to the other case and concurrent to each other. In May of 2012, there was a conviction for resisting obstructing. He was sentenced to 37 days jail consecutive to the earlier sentence imposed in April of that year. He's currently pending on 2 charges in Milwaukee County. 2020 CF 2550, he's charged with 2 counts, second-degree recklessly endangering safety while armed, and 1 count of felon in possession of a firearm. The date of that offense, or excuse me, all 3 offenses is July 24th, 2020. It's believed he was arrested shortly after that incident and remained in custody in the Milwaukee County Jail until released on bail there for reasons of a speedy trial violation on March 3 of 2021. Bail at that time was lowered from $7,500 cash bail to $500 cash bail. In that case, Your Honor, it is alleged that he got into a fight with his nephew. The defendant fired one round from a handgun toward the vehicle that his nephew was in. The vehicle was occupied by another person, and that accounts for the 2 charges of reckless endangering safety. The next day, he was taken into custody, and the residence where he was located, he was found to have a loaded 9mm handgun just a few feet away from him. The handgun was previously reported stolen. Again, he was a convicted felon on that date, so that accounts for the 3rd charge. He's also currently pending in Milwaukee County case number 21 CF 4596. That has a date of offense of November 2, 2021. He's charged there with resisting, obstructing, felony bail jumping, 2nd-degree reckless endangering safety in a domestic violence situation, domestic DC, and domestic battery. The allegations in that case, Your Honor, are that he struck the mother of his child in the face with a closed fist. Then as she was walking away from him, he intentionally ran her over with his vehicle. The vehicle in that matter described as what's believed to be the same maroon 2010 Ford Escape used in the allegations in this case. Police went to his home and found him getting out of that Ford Escape. The defendant ignored their commands to stop, and he tried to run into the house before he was apprehended. There's a long history of flight, obstructing, bail jumping type behavior, Your Honor. It's remarkable that these are violations all around the state of Wisconsin, not just his home county of Milwaukee, but we had convictions from Wood County, Manitowoc, and Langlade. I'd like the court to be aware of a record from the state of Nevada. We'll go to Nevada first. That happened, the first conviction was from December 11th of 2006. He was found guilty at trial of a misdemeanor count for obstructing an officer, was sentenced to jail in Nevada. Also on that same day of December 11, 2006, he pled guilty to a domestic battery as a misdemeanor, and the court there ordered a suspended sentence. On March 16th of 2007, he pled guilty to statutory sexual seduction, a felony. The court ordered a suspended sentence for 36 months probation. He was also ordered to register on the Nevada Sex Offender Registry. He is currently noted to be non-compliant with that registration requirement. On June 23rd of 2016, he was charged with a sex offender registry violation, first offense. He failed to appear in court, and a warrant remains active for his arrest. So he currently has an outstanding warrant for his arrest in the state of Nevada. In Georgia, Your Honor, the record reflects a May 27, 2021 arrest for misdemeanor battery with a designation of family violence. While it is not clear if he was convicted, he did recently remark to a court official in this county that he had served a 6-month jail sentence in Georgia. So we have not been able to verify if that was a conviction, but certainly there was a confinement in conjunction with that arrest. He has no contact with the criminal justice system in Waukesha County or the district attorney's office. He does have a outstanding paternity case that's been pending since 2003, in which he was adjudicated as the father of a juvenile. And there's been returned court appearances over the years based on failure to pay child support. The court should know that a warrant or capias was issued for Mr. Brooks in this paternity case on at least 8 occasions. He has been sentenced to jail on several prior occasions for failing to pay that child support. And on one occasion, he had his Huber privileges revoked related to one of those jail sentences. That was back in 2009. Most recently, there was a warrant issued for his arrest in that non-support civil case On August 2 of 2021, Judge Maxwell signed an order for him to serve a 120-day jail sentence. Mr. Brooks did make a court appearance in that matter on November 16th of 2021, so just last week, 1 week ago. And he was released at that time because, again, he had explained to the court, provided an explanation that the reason he had not made his child support payments is because he was serving that jail sentence in Georgia. So the court released him that day and ordered him back for a court appearance in the paternity case for December. So Judge, just based on his prior record, we obviously have very significant concerns about Mr. Brooks' flight history and willingness to obey the orders of the court. But we have to factor in, obviously, the allegations in this case as well. And obviously, I don't need to state Mr. Brooks is facing 5 consecutive life sentences if he's convicted on all counts in this complaint. I wish to notify the court, sadly, that today we learned of another death of a child related to this case. We do expect a 6th count for first-degree intentional homicide to be issued or added, to this case. I can advise the court that I am aware, I've been made aware through investigators that there are other individuals in critical condition. I think we remark on the number of actual injured parties in our complaint. It exceeds 60 people. There's a number of other charges that we are reviewing and considering, but certainly at the very least, we do intend to file a 6th count of intentional homicide, maybe Friday or maybe early next week, depending on when we can accomplish that. Certainly, if we have any other deaths resulting from this incident, additional counts of homicide will be filed. We didn't charge bail jumping. Obviously, we could have. We have focused our efforts to date on the immediate concern, and that involves the loss of life that is alleged to have occurred through the conduct of Mr. Brooks. I want this court to know, and I think the court has read the complaint, you've indicated you've read the complaint. There are not words to describe the risk that this defendant presents to our community, not only flight risk, but the dangerousness that he presents, his history of violence, and the allegations in this complaint where it is stated plainly that on several occasions he was told to stop by police officers. They risked their own safety to try and step in front of the car to stop him. Everything was done to get him to stop, and he just simply continued down the roadway, causing death and destruction in his path. So I am advocating for a significant cash bail, Your Honor. I'm asking for $5 million cash bail. I know that's a large amount of money, but I think it is warranted on this history, and I think it's warranted when the court considers, if convicted, Mr. Brooks will spend the rest of his life in prison.
Hi. Look at all you guys. We got a lot of OGs in the house. I said you guys. Now, see, I know who my true fans are. I stopped showing Brooks, and y'all all left me like a bad habit. No, I know who stayed. Don't get sensitive on me. I'm just saying. All right, you guys. So I'm going to put up the charges really quick. We're here early because, I mean, come on. This is our last hurrah. Oh, I guess I should call the meeting to order. Let me do this. I tried to do this earlier, but there's more people here. Welcome to the Brooksaholics. Welcome to the Brooksaholics Anonymous Club. It is officially in session for the last time. For those of you who have an issue or are Brooksaholics, please do not use your real names, but feel free to place in the comments and in the chat any issues you have with this case. Today, we close the books on a long-awaited sentencing. Darrell Brooks. God, I just called him a doctor. What's wrong with me? And I've had 3 cups of coffee already, you guys. Darrell Brooks will be sentenced today for the attack on Erika Patterson, which was November the 5th of 2021. Let's see. Surveillance and witnesses show and describe him running over her with the same vehicle that he hit many people in the Waukesha Christmas parade. Also, jail phone calls show how he tried to intimidate her after this, before the Waukesha parade, to get her not to testify against him. And I think he almost had it. Anyway, for you guys that are here looking for what's going on with his appeal, it has been extended many times, and currently the latest deadline is Friday, October the 18th. Now, that's for his sentencing, or that's for his charges in the Waukesha Christmas parade attack. This is the deadline for his appellate attorney to file the actual appeal itself. So they've asked for another request. So that'll come back. It seemed kind of interesting, though, that it's a 2-month, usually like in the past, they had like a 2-month extension. But on this particular one, they lowered the extension to 48 days. Now, it could be the time of year. I heard Vinny Palatino, or whatever his name is, say one time that this time of year in the fall, it gets really busy with the court dockets. So it could be the time of year, and that's why they're scheduling it that way. What else did I want to tell you guys? Oh, you guys know Leslie Basie. She won the primary race for the Waukesha DA, right? Whoop, whoop. All right, Leslie. You go, girl. Mm-hmm. All right, what else? And also, you know what I was thinking about? I was watching one of these older hearings, and we're going to continue to watch some of them. I noticed that on one of the hearings, he said, this was when he still had those other 2 guys as his attorneys. He said he was requesting pro se only if it went to trial. And you know what I think? I think he wanted to have his last go at Erika. I do believe. All right, let's go back to watching some of these. I've got another hearing here that I thought would be fun for us to watch until this other case, because we've got at least another 40 minutes probably before they bring it up. So if you're hang out, listen if you want to, come back later, however, but please join us at 1:30 p.m. Central Standard Time. We will have this live as long as they're streaming it. I do have the courtroom feed up from the Milwaukee County courtroom. They have not been putting a whole lot on that, but if that one's up, we'll also have that one as a backup if there's no media. But you guys know there's going to be media. There's going to be media. All right, let's show this other stuff. So this was, what date is this? This was 2 years ago. This was on February 2nd of 2022. Robert Hamilton, that was his name, or Hampton.
21 CF 5020. Appearances, please.
Matthew Tarbinson appears for the state. Good afternoon, Your Honor.
Good afternoon.
Attorney Robert Hampton appears with Mr. Brooks via Zoom. Madam Clerk, you call both cases or just one?
Both. Yeah, we called both.
Okay, and on the new case then, yes, I've gone over that new case with Mr. Brooks and I waive any formal reading.
What did I say, Judge?
For the new case, the address on the complaint is correct for Mr. Brooks. A phone number for Mr. Brooks on the new case is 414-339-5677. Mr. Brooks is eligible public defender assistance, Your Honor. Good afternoon.
All right. Good afternoon. Good afternoon, Mr. Brooks. We are here on 21 CF 5020 for an initial appearance. This is our Zoom week, so Mr. Brooks is appearing by Zoom after being transported from the Waukesha County Jail, as they do not have Zoom availability for defendants who are housed in their jail. Mr. Hampton, do you consent on behalf of your client to appearing via Zoom today?
Yes, Your Honor.
All right. So as I said, we are here for an initial appearance on the new case. The older case is set for a status. So Mr. Brooks, your attorney has waived formal reading. I do want to just go over the penalty sections of this to make sure that you do understand this. On count 1, you're charged with felony intimidation of a victim. For that, you face the potential penalty of a fine of not more than $25,000 and imprisonment for not more than 10 years or both. On count 2, it's felony intimidation of a witness by a person charged with a felony. That is also a Class G felony, and again, carries with it that potential penalty of a fine of up to $25,000 and imprisonment for not more than 10 years or both. Count 3 is felony bail jumping. That is a Class H felony, and for that you face the potential penalty of a fine of not more than $10,000 and imprisonment not more than 6 years or both. Mr. Hampton, I have reviewed the complaint and do find that it does state probable cause as to these matters. Would you like to enter well, we need to set it for a prelim, sorry. Are you setting it for a prelim? Or taking other action today?
Yeah, set up for a prelim, please.
Okay. All right, we will set it for a preliminary hearing. We will have to, I assume, do the same thing today that was already done for this matter, to have Mr. Brooks produced to our jail. So we will set that on prelims calendar as he is in custody. Do you want the other case, the older case, to just tag along there as a status so they stay together?
Yes, that makes the most sense.
All right.
One question, Your Honor, for the preliminary hearing. Will that be in front of you or will that be in prelim court?
Because he's in custody, it'll be in prelim. I can take it if you would like me to. If that makes scheduling, if there are scheduling difficulties, but it generally would go to prelim because of the
Oh no. Stop the lagging. Stop it. Hang on, y'all.
Yeah, and our understanding all the other matters that Mr. Brooks has opened, the state's request on this case is $50,000 cash bail. Briefly, Mr. Brooks has 8 prior criminal convictions in Wisconsin, at least 1 criminal conviction out of state. At the time of these offenses, if they prove to be true, he had 2 open criminal cases in Milwaukee County, one of which he was out on bail. The other one he posted after being charged on this. He has demonstrated through his conduct, if these allegations prove to be true, that he commits crimes whether he's in custody or out of custody. So based on all of the factors before the court and without even touching on the extraordinary serious allegations from Waukesha County, I think $50,000 is minimal and appropriate on these charges in this case.
All right, Mr. Hampton.
Thank you very much, Your Honor. Your Honor, Mr. Brooks and I both recognize that cash bail is appropriate in this particular situation. I'd be asking in the range of about $5,000 to $10,000 in this particular case. We already know where Mr. Brooks is going to be for the foreseeable future and probably beyond that as well. We know, his circumstances are not changing anytime soon. On one hand, this is a moot argument because he's not going anywhere. But I'm looking at the circumstances of Mr. Brooks. I'd ask something in the range of about $5,000 to $10,000. I think that's an appropriate number considering the charges, considering the history, and considering the future of Mr. Brooks in the state institution, Your Honor. Thank you.
All right, thank you. I do think that $50,000 cash is appropriate. I did set $200,000 on the underlying case, but these do involve threats of intimidation and efforts to intimidate, but also to undermine the authority of the court. I think it is appropriate. They are merely allegations at this point, but it does demonstrate a lack of recognition of the authority of the court and court orders. So I think $50,000 cash is appropriately an appropriate amount. I will set that. If there is to be any release, it will of course be a turnover to justice point at level 5, but I think we all know that that does not look like that is on the horizon. So we will get a date in preliminary court for you to proceed there. And if you are bound over, that both cases will come back to me, otherwise just the first will.
Madam Clerk, the lead investigator on this case is only available on February 14th or 15th. Are those dates workable by chance?
Well, it's a 10-day, so I have to call prelim court, but it has to be within 10 days unless the defense is waiving.
When is 10 days up?
10 days is February 14th. Oh, wait, I'm sorry, hold on.
No, it's on the 15th as well.
One moment.
Just 1 second, Mr. Hampton.
All right, I'm sorry, state and defense, the 10th day is the 11th.
All right.
Is the defense waiving their 10-day time limit or no?
No.
Okay, so it has to be done before February 11th. State, do you need a morning or a PM?
Morning, please.
I need a prelim, in custody prelim date for prelim, sorry. A morning. Okay, how about February 10th in the morning?
Either the 9th or the 11th, not the 10th.
Is the 9th available? State, does the 9th work for you?
Yes.
All right, and that's Darrell Brooks, 21 CF 5020. So much. Okay, bye-bye. All right, the next court date will be February 9th at 8:30, and that will be in prelim court for a preliminary hearing as to case ending 5020, and it will be for a status as to case ending 4596.
Thank you.
Thank you.
Have a good one.
Bye-bye.
How do I turn this thing off? Hey, I don't know how to turn this thing. Am I muted?
Okay, Mr. Brooks, we're all done.
Go away. You can walk from the camera now. Hey. Hey. Can I call an Uber? Oh, thank you, JPC. 17 months. Dang, you are an OG. You are a real OG. Yeah, we're playing older videos, guys, just because we're waiting for this to come up. I wanted to get started early, get everybody in here, so y'all don't forget that this is happening. This is our last hurrah. Oh, wait, I take that back. This is Darrell's last hurrah. We hope Erika's going to be there today. We hope she gives an impact statement, if only just by Zoom, we're hoping. And she did file a victim restitution request form. I don't know exactly what that is. If anybody knows in the chat what it is, type it in there. It kind of, I'm sure it speaks for itself, but I don't blame her. I would have too. He can't make any money. It's probably just somebody told her to do that just to be on the safe side. I'm still checking background to make sure we're not going to miss anything. Until then, I did have one other thing I wanted to play. Now, this is the one where he takes the plea deal for this specific case. The sound starts late. It'll come up in just a second. Hey, Harry. I apologize if I can't say hey to everybody because there's a lot of you guys in here today. Yes, please click that thumbs up button. I need the YouTube algorithm to love me.
Darrell Brooks Jr., 21 CF 4596, 21 CF 5020. Appearances, please.
Matthew Torbenson and Shelley Grosso appear for the state. Good morning, Your Honor.
Attorney Russell Jones, on behalf of Mr. Brooks. Mr. Brooks is present in court, Your Honor, in jury clothing. Good morning.
Good morning, everybody. Hi, Mr. Brooks.
Hello, Your Honor.
We are here. It is the day that our trial was scheduled, but I have plea paperwork and I understand that the parties have reached an agreement. Mr. Torbenson, do you want to put the state's offer on the record?
Case ending 4596. The state anticipates Mr. Brooks entering a no contest plea to count 3, second-degree recklessly endangering safety as an act of domestic abuse. Based upon that plea to count 3, the remaining charges would be dismissed and read in for consideration at sentencing. As to case ending 5020, the state anticipates Mr. Brooks entering a plea of no contest to count 1, felony intimidation of a victim. Based upon that plea, the state would move the court to dismiss and read in the remaining 2 charges for consideration of sentencing. At the time of sentencing, the state will recommend that the court sentence Mr. Brooks to a substantial term in the Wisconsin state prison system. We will leave the ultimate interpretation of that to the sound discretion of the court. The defense would be completely free to argue for the appropriate sentence.
It also contemplates the amended informations not being filed.
Okay. Mr. Torbenson, you talked about count 3 as charged, correct?
Yes.
Okay. All right. Mr. Jones, is that your understanding of the state's offer?
Yes, Your Honor, and I actually did an attachment of an email string between the state and I for clarity of the record.
Okay, I appreciate that. And
I had Mr. Brooks' initial next to the offer section.
great. You're planning or anticipating that it will be a no contest plea. Do you want to make a record as to why that is rather than a guilty plea?
Yes, Your Honor. My client is entering a no contest plea. In those discussions, I indicated that he understands that he'll be found guilty, but he is standing silent he's not contesting the allegations because of potential civil liability, which he may or may not be exposed to with respect to these charges, and therefore we've negotiated a no contest plea. But I will tell you that he understands he'll be found guilty. This is not a maintaining of innocence thing. This has an issue. This is a legal decision based upon potential civil liability.
All right. And the state that was part of your offer, and you are willing to accept a no contest plea for those purposes?
I am understanding that the victim, Ms. Patterson, can still seek restitution in these matters if she so wishes. We are not objecting.
All right. All right. And the court is willing to accept it for the reasons that have been stated on the record. The named victim will have the opportunity to put in a request for restitution that is separate from a civil liability thing. So that will still be a potential that will be part of this. So, Mr. Brooks, it is my understanding that you are planning to enter a guilty plea today to
no
2
contest.
charges. See, I told you I would do it.
I know you did.
It is habit. I apologize. A no contest plea to 2 of these charges that are pending against you. Is that correct?
Yes, Your Honor.
All right. Have you had any drugs or alcohol in the past 24 hours?
No, Your Honor.
Are you on any medications?
No, Your Honor.
Are there any medications you're supposed to be taking that you have not taken?
No, Your Honor.
So you've been charged with a number of counts in each of these cases. It's my understanding that you're going to enter a guilty plea to the 2, or sorry, did it again, no contest plea to the 2, and then the other charges will be dismissed and read in. What that means is for the dismissed and read in counts, you will not face any penalty for those, nor will you have a conviction for them. However, when we get to sentencing, the state will make their argument as to the facts of the case, and they can argue the facts that relate to those dismissed and read in charges. And I can take those into consideration when I sentence you on the 2 that you entered the no contest plea to and that you were ultimately found guilty of. Do you understand that?
Yes, Your Honor.
All right. So for the 2 that you are going to enter the no contest plea on, the first is a second-degree recklessly endangering safety with a domestic abuse assessment. That means that it is a Class G felony, and for that you face the potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years or both. That 10 years is broken down into 2 parts, 5 years initial confinement and 5 years extended supervision as a maximum. Do you understand that's what you're facing?
Yes, Your Honor.
In addition to that, because of the nature of the crime, that this is someone that you have been involved in a domestic relationship with, or either resided with, or have a child with, you would face the domestic abuse assessment for that, which is just an additional $100 penalty that would apply against you, as well as a federal ban on ever possessing a firearm. Do you understand that?
Yes, Your Honor.
All right. And then on the count 1 felony intimidation of a victim, that you're going to enter the no contest plea on in case 21 CF 5020. That is also a Class G felony, potential penalty of a fine of up to $25,000 and imprisonment of not more than 10 years, or both broken into that 5 years initial confinement and 5 years extended supervision piece. Do you understand that?
Yes, Your Honor.
Do you also understand that if you were to be sentenced to prison, you would have to serve in prison each day imposed as initial confinement, because initial confinement time is not reduced by good time or by parole?
Yes, Your Honor.
Do you further understand that when we get to sentencing, I was not part of any negotiations, so I'm not bound by anybody's offer or recommendation. I will listen to what the state has to say, anything that the alleged victim has to say, either in writing or in person or in, I guess, any other form. Anything that your attorney says, anything that you say, and anyone who speaks on your behalf. I will take all of those things into consideration, and then I'll sentence you as I see fit, which could be up to and including the maximum penalty. Do you understand that?
Yes, Your Honor.
Do you also understand that because these charges are felonies, once you are convicted, there's some additional consequences, including the fact that you will never be allowed to possess a firearm at any time in the future. You may not vote in any election until your civil rights are restored. You will have to provide a DNA specimen to the Wisconsin State Crime Lab for DNA testing. And because these are violent felonies as defined under Wisconsin law, you may never possess body armor at any time in the future. Do you understand that?
Yes, Your Honor.
Do you also understand that if you are not a citizen of the United States of America, the plea of guilty or no contest for this offense with which you were charged may result in deportation, the exclusion from admission of this country, or the denial of naturalization under federal law? Do you understand that?
Yes, Your Honor.
Do you further understand that if you enter a no contest plea, you will be giving up all the same rights as if you had pled guilty? And at the end of this, even if you enter a no contest plea, I will find you guilty of these crimes. Do you understand that?
Yes, Your Honor.
All right. So what is your plea then in 21 CF 4596 of second degree recklessly endangering safety with the domestic abuse assessment?
No contest, Your Honor.
All right. And in 21 CF 5020, intimidation, felony intimidation of a victim.
No contest, Your Honor.
All right. Now I have in front of me your plea questionnaire and waiver of rights form. Did you go over that with Mr. Jones and sign off on it today?
Yes, I did, Your Honor.
Do you understand that when you say no contest, rather than asking for a trial, you give up a number of constitutional rights that are guaranteed to you? Those include your right to remain silent and not incriminate yourself, the right to see and cross-examine the state's witnesses, as well as call witnesses on your own behalf and have them come to court to testify for you, the right to actually have a trial, which could be a jury trial where 12 people sit together, listen to the evidence, and then must agree as to each element prior to reaching a decision, or a court trial where the judge listens to the evidence and makes a decision. And finally, the right to make the state prove you guilty by evidence beyond a reasonable doubt that you committed the crimes charged. Do you understand you give up all those rights when you say no contest rather than asking for a trial?
Yes, Your Honor.
Do you also realize you're giving up the right to raise any motions, such as suppression of the evidence, identification of you as the person who committed the crime, suppression of any statement you may have made, or any challenges to the information or the complaint?
Yes, Your Honor.
Do you also realize you're giving up the right to raise certain defenses you might have, such as insanity, self-defense, intoxication, alibi, coercion, and necessity?
Yes, Your Honor.
Did anyone make any threats or promises to get you to enter into these pleas today?
No, Your Honor.
Did you read and understand the criminal complaints that were filed in these cases?
Yes, Your Honor.
And did you discuss with your attorney the elements of these offenses?
Yes, I did, Your Honor.
Do you understand that if we had a trial, the state would have to prove as to the second degree recklessly endangering safety that on November 2nd, 2021, at 7311 West Capitol Drive, that you endangered the safety of another human being, that you endangered the safety of another by criminally reckless conduct. That criminally reckless conduct means that the conduct created the risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and you were aware that your conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means serious bodily injury, injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury is great bodily harm. Do you understand that's what they would have to prove at trial if we had a trial in this matter?
Yes, Your Honor.
And you understand that by pleading no contest, you are admitting that you believe that the state has adequate evidence upon which they could convict you, and you are opting not to challenge that evidence. Is that correct?
Yes, Your Honor.
As to count 1 in 21 CF 5020, do you understand that's the felony intimidation of a victim, that if we had a trial on that matter, the state would have to prove that between November 5th, 2021 and November 15th of 2021, from 949 North 9th Street, that, what are the initials? EP?
Yes.
EAP, was the victim of a crime, that you prevented, dissuaded, attempted to prevent, or attempted to dissuade EAP from reporting the crime to any law enforcement agency, and that you acted knowingly and maliciously. Do you understand that's what they'd have to prove as the felony intimidation of a victim?
Yes, Your Honor.
And you understand that by entering that no contest plea, you are admitting that the state has adequate evidence that they could use to convict you of that, and you are opting not to challenge it. Is that correct?
Yes, Your Honor.
Have you had enough time to go over this case with your attorney?
Yes, I have, Your Honor.
Are you satisfied with his representation?
Absolutely, Your Honor.
Do you have any questions, or are you confused about anything we're doing here today?
No, Your Honor.
Are you pleading no contest because, again, you understand the state has adequate evidence upon which they could use to convict you, and you are opting not to challenge that evidence?
Yes, Your Honor.
And are you entering this plea freely and voluntarily?
Yes, Your Honor.
Mr. Jones, have you gone over the plea questionnaire and waiver of rights forms with your client?
I did.
Are you satisfied that your client understands the nature of the charges, the elements, the maximum penalties, and all of the rights that he's giving up by pleading no contest, including the fact that he will be found guilty, and also including any possible motions or defenses?
Yes, Your Honor. And to that end, I also handed Mr. Brooks about 100 and some pages of reports today, just so we would have them. The witness list, the amended information, and there's additional documents I'll be sending to him. Although he has them on digital format, I wanted him to have them in paper format. We went through the no contest discussions. We also had a discussion, not just today in your bullpen, but also, and I'm not getting into the substance of it, but also on Saturday, we were able to have a fruitful conversation. So I think that Mr. Brooks is doing this knowingly and voluntarily.
All right. Are you satisfied that alcohol, medication, or drugs are not affecting your client's ability to understand what he's doing in court today?
I am.
Are you satisfied the plea is being made freely, voluntarily, and intelligently?
I am.
Are you aware of any reason in law why I should not accept this plea?
No.
Does the state consent to the jury waiver?
We do.
All right. The court approves the waiver and finds that the defendant is entering this plea freely, voluntarily, intelligently, and with full understanding of the nature of the charge, the maximum possible penalties, and all of the rights being given up by pleading no contest, and the court accepts that plea. Mr. Jones, may the court use the facts in the criminal complaints to stand as the factual basis?
Yes.
All right. Mr. Brooks, you said that you read and understood the criminal complaints. Are you agreeing that you believe that the state could prove that those facts are true, and therefore you are opting not to challenge them with your no contest plea?
Yes, Your Honor.
The court finds that there is a factual basis for the acceptance of your plea, and based on your pleas of no contest, the court now finds you guilty of the offense of second-degree recklessly endangering safety with the domestic abuse assessment and felony intimidation of a victim in the manner and form as charged in the information, and I judge you convicted as of today's date, and I order judgment of conviction to be entered into the record. Is the state moving to dismiss and read in the 21 CF 4596 counts 1, 2, 4, and 5?
Yes, and counts 2 and 3 on 5020.
Okay, you got there before I did. That's fine. All right, those will be dismissed and read in for the purposes of sentencing. It is my understanding that we're setting sentencing off for another date. We will select that date in just a moment. At the time of sentencing, Mr. Brooks, and I am going to keep this. This was, I had this case in the domestic violence court. I came to another assignment, but I kept it because I had done much work on it, and I thought for continuity it was best. I will be transferring to another assignment in August. If we get a date before that date, I am specifically keeping this case. I will see it through. So at the time of sentencing, I am willing to listen to oral statements of counsel as well as anything that you have to say, Mr. Brooks, as well as EAP. If you would like to have a friend or a relative speak on your behalf, I'm more than happy to talk to that person. If there's more than one person who wants to do that, they should put their comments in writing and get them to Mr. Jones so he can electronically file them at least 3 days prior to that sentencing. If there are issues of restitution, that will be determined at sentencing if possible. Is there a request for a pre-sentence investigation?
No.
No.
All right. And
I'm not moving for remand. I normally would in a case like this, but given where Mr. Brooks is serving a sentence and my understanding that Mr. Brooks wants to return back to Boscobel, I'm not asking for remand.
Right. I agree with that.
Correct.
Generally, I would remand someone given the seriousness of the charges that you just entered into and that what the state's recommendation of substantial prison would be. But given your situation, I don't want you to have to be held in the Milwaukee County Jail rather than returning to the prison setting where you have been housed. So I am not going to remand for that specific reason. I know you will be held. That is the court's goal, that you be held in custody, just not necessarily here. So
Thank you, Your Honor.
You're welcome. All right, so I have some warnings for you. You may not have any firearms as you are now a convicted felon. The maximum possible penalty you face for violation of that is a $25,000 fine and a 10-year period of imprisonment. You cannot vote until your civil rights are restored. You may not possess body armor, and any no contact order remains in place at least until after sentencing. All right, we will select a sentencing date, and I will see you then.
Okay. Thank you, Your Honor.
You're welcome.
Parties available August 9th at 9 o'clock.
No. That week I can do any of Monday, Tuesday, or the Wednesday, not the Thursday or
Am I muted? That was the old, I guess, the last hearing they had. And then they were supposed to go back in August, and they came back and they changed it on us. And now here we are. You know, I just thought about you guys after looking in the chat. Where's John Bubba at? What happened to him? Y'all remember John Bubba? All right, let me see something. I don't know what made me think about him. I got this pulled up. Let me share this with you guys in case it happens. I've got that pulled up, but I think more than likely we're going to get it off of like Law and Crime or Fox. So I've got that going as well. So they should be pulling it up here in the next, I would say in the next few minutes. Well, at least 10 minutes. It's 1:20 now. So we shall see. I want to read some of your chats until then. Oh, yeah. Oh, he posted a few of mine, so he's still around. Okay. All right. Yeah. Speaking of which, you guys go over and check out Laura's channel at Interesting Captures. She's got some cool stuff on John Wayne Gacy. Her family knew him. Okay. Let me go back to my notes because I know a lot of you guys are new in here and were not here when I first read this. Today is the day. This is it. This is his last hurrah. Probably the last time that he will see Erika. And we don't know if she's coming in via Zoom or in person, but we certainly hope she comes in. Now, she did file for a restitution request form. And they said that, let me see what else. Oh, let me give you the update on his appeal. So his appeal deadline for the Waukesha parade case, that was Friday 30th. His attorney, appellate attorney, did submit a new request for another extension, and they have extended it to Friday, August the 18th. So it seems like they've done another 48 days for him there. So we'll come back to that later and check that. As most of us know, this isn't going anywhere. At least we don't think it is, right? We don't think it's going anywhere. So for all of you in the Brooksaholics Anonymous Club, thank you for coming in. We've been in session for about an hour now, and today we are closing the books on the long-awaited sentencing of Darrell Brooks for the attack on Erika Patterson on November the 5th of 2021. And what else? I think that's all. Let me look at y'all's comments. Y'all had some great comments. It's not on Law and Crime Network. I think it's too early. I've got all of them pulled up. I've got Fox. I've got Wizen 12. I've got, they just had some kind of standoff or something over in Milwaukee. Fox 6 has been the one that's been covering it the most, I think, in these hearings. So I kind of anticipate them to be the one. But at the same time, I do feel like Law and Crime's going to be on it. They don't have any other court trials streaming right now. They have that one at 3 o'clock for that guy. Do you know the guys that they jumped over the judge's thing and attacked the judge? Y'all remember that? Well, he's on trial right now for that, just for that. I was listening to the opening remarks this morning. They were very long and drawn out. Very long and drawn out. Okay, 1:30 p.m. Here we go. TMJ4's got it. Now that surprises me. You go, TMJ4. Let's pull them up. They haven't always been on top of it. Wait, what's playing? I don't know what's playing. I don't know where it's coming from. Can y'all hear it? I can't get this to go away. Okay, I got it. I don't know where that was coming from. I'm being possessed by Darrell Brooks. You go, TMJ4. I didn't think you were going to come through, but you did. All right, so we know we got one reporter with a camera in the courtroom. All right, so let's look at these chat. No, Carrie, what? No, what'd I do? What'd I do? Bruiser was singing. Hey, John Penman. How long has it been since your last Brooks video? Possessed by Brooks. I am. Oh, that's what you were talking about. Okay. I thought I did something wrong. Let's see. I watched every time thing about Sarah. She makes me so mad. I know. I'm giving Sarah. I have a well-needed break from Sarah today, you guys. Big time. Ugh, she's getting on my nerves. Oh, the guy that jumped the judge, he was claiming that he was off his meds. I'm reading y'all's chat. Yeah, they're on Law and Crime. Don't leave us now, but when you leave here, go to Law and Crime, and they've got that hearing for that guy. I want to try and attend the Waukesha Christmas parade this year. Really, John? That'd be cool. Will you take some videos for us? Some videos? Take some videos for us. He should just file a no merit to not offend the court. Obama. Okay, let's see. Hey, Dennis. Friendly reminder to please hit that like button. I appreciate you guys for doing that. It helps me with the algorithm and the cigarithm and the biggerigum and the muggerigum. I don't know. It's been a long, strange trip. Oh, Bama is passing on her Brooksaholics hat to a Boonie hat. You know, I've actually had people that got offended because I called them boonies. I think they misunderstood. Erika needs to be holding a mic so she can drop it when she gets done. You go, Louise. Louise. That's my favorite. That's my favorite today so far. Girl. Hey, Miss Monica. We need a Brooksaholic annual meeting every year. We might have to do that. Oh, the guy, second best art museum. Are you talking about the guy that jumped over the judge's thing that his attorney actually submitted an appeal? Which one are you talking? What trial are you talking about? After this, the next time I hope to hear about him should be with his obituary. Oh. Yeah, I wonder, like, when they're going to put him in Gen Pop. We don't feel like he has a whole lot of hope. My only worry is, though, is that because he has a little bit of popularity, that he's going to get he's going to have some people want to befriend him, and he's going to try to get some money from people. Oh, Mel straightens this whole thing up about the wheelchair. She says that his first appearance, he had refused to come out, and he's also a lifer sentence prisoner. And I believe that there is not a separate area for prisoners, only enter and exit. So, okay. That's why he was in a wheelchair this past time. I know. Where's Tony, Naomi? That's a good point. I forgot about Tony. Whose turn was it to babysit John, Bubba? Naomi wants to know if we're going to address subject matter jurisdiction. We've already addressed that, Naomi. I've already ruled on it. You can go back and look at my ruling. I gave you a copy of it. Gave you a paper copy of it, Naomi. Y'all just go ahead and get it out of your system. Just put your one-liners in the chat now and get it out of your system. Where did Eric go? I can't believe Eric's not in here putting his one-liners in. Erika deserves her day, and also it's in case an appeal would throw out his previous life sentence. Not that it would happen, but just in case. Oh, it's like yeah, you're explaining that. Yeah. I mean, a lot of people are saying, why are we doing this? Why are we even bothering? He's in jail for the rest of his life. But it is for the victims. And it doesn't hurt to have a plan B and C when it comes to this lunatic, right? I mean, do we really want to see him out ever again? No. No. We do not. Let me refresh the screen, make sure it didn't already come on. Sometimes it does that. I noticed that. You have to refresh. No, it's okay. So before it gets started, sound is good for everybody. Let's hope that the sound in the courtroom is good. Please note, I can't control that. I do my best. I've got it on full blast here. You guys, I'm worried about my Frankie. He's a big dog, and he's been like really panting a lot more lately than normal, and he's hacking. And I gave him heartworm medication. I don't know what's wrong with him. I'm gonna have to take him to the vet. Mark, it should be known to everyone that Mark had given up a date with a hot woman to go to the casinos to be here today with us, and we do appreciate that you did that, Mark. He told her that he had a therapy session Said that always works. Oh, Nunya. I only get my Brooks fix from Characters Productions. Well, aren't you cute? I'm loving that. Fazini, how you been? Where you been? Where you been, Fazini? Is he sedated? I don't know, Bellis. Wow, we got 915 people in here. Y'all, please, if you don't mind, please, 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 hit that like button. Laura even rescheduled. Oh, Lenny even rescheduled her doctor's appointment so she could be here with us today. Aren't you cool? I love that. Y'all are awesome. My uncle is going into surgery next week, and I was like, oh my God. I know this is horrible, but I was like, please let him go into surgery before the Sarah Boone trial, because I need to go over to the hospital and stay with him. Y'all are going to have me. I'm going to be coming in doing feeds from outside the hospital. Okay, gosh, I've only got 15 minutes, but let me give you the update. Can you imagine? I would do it. I would totally do it. The guards would come over and be like, ma'am, you can't be. No, they'd be like, ma'am, you can't smoke over here. You can't smoke on any of the at the hospitals anymore outside, even in the parking lot. I'll go get in my dang car and smoke if I have to. It stresses me out being in hospitals. Ozzy says, if E is there, this is possibly last chance to ever see her face again. Exactly. Exactly. Psychic, he didn't want this. He wanted to keep playing games. I wonder what they said to talk him into a plea. Good point. We were all kind of flabbergasted with that, weren't we, Psychic? Like, why did he take this plea? It just didn't make a lot of sense. I just refreshed it. Still nada. All right, let me look at my plan C and make sure we're not missing anything. I don't think we are, but let me just look. Nope, Fox 6 is not live right now. They're probably just late getting into court. They never start on time. And with the time of day that this is, I can only imagine that, they run behind in each case usually. So then before you know it, they're 15, 20 minutes behind. It's not like where this is the first case of the day. So we'll see. We're not going to miss it. Don't worry. I'm kind of surprised that Law and Crime's not there. The Sarah Boone update today. No, there's nothing. You guys, were y'all watching that shooting yesterday? I could not stop watching it. It was heartbreaking. And I was missing, there was a couple of YouTubers online last night that were talking about it as if it was like the moms had drug issues and the families had abuse, a lot of DV, and he didn't come from a good space. Are we going to see more parents go to court? We possibly could on that one. So sad, though. When I first moved to the Atlanta area, I lived in Norcross, which is like, I don't know, it wasn't that far from where that was. I lived in Atlanta for about, I think, 13 years before I moved to Florida. Hang on, let me go down to the bottom and read y'all's chats. If I'm missing anybody's chats, I do apologize. Okay, who just said that? Hang on, let me check. Pull it up. Even if we're a few minutes behind, it's okay. As long as we get I want the whole hearing. That's all I care about. I don't have anything coming up for him. For today. Let me go to live. No. Did somebody just say they thought it was online? It's not online crime. Linda has said that. I don't see it, Linda. I just searched his name. Take out all the filters here. I'm pretty certain that TMJ4 will open up as soon as he's on. It's probably just running behind. That's all it is. It's old video. That's what I thought, Linda. Don't scare me like that, Linda. You gave me a heart attack. Girl. Darrell probably didn't want to get on the court bus. Oh, that's a good one, Mimi. You know what, John? I don't think that Judge Darrell and Sue Opera would waste their time, any more of their time on Darrell Brooks. I just don't see him coming in. Benny says, I hope Erika roasts him good. Well, we know that chats wants and paint. We know that she's got a new man, right? Doesn't she? Nothing happened on Brooks yesterday. I haven't been on Erika's channel in a while. I think the last time I looked was oh. It's like they're behind in the feed. There's no sound though, guys. I've got it up on high, okay? See, they haven't started yet. I told y'all we're okay. We're okay. Nobody panic. Or is that me panicking? It's probably me. Yeah, I don't do politics. Who said something about yeah, no politics here. You know why? You know why I don't do politics? It's because if you go on to Twitter, it breaks people apart. It breaks families apart. It breaks friends and work people apart. It's just like, this is my workspace. I'm not going to bring politics into it. I have my own opinions. I know exactly the way I feel about it, and I have some strong opinions on it, but I'm not going to put it out here on my channel. Because there's no need to. We don't talk about that on my channel. We talk about crime. Now, every now and then, stuff that we do, you will be muted. Where did you go, Paul? Where'd you go, Laura? Oh, shoot. The chat's going too fast. Holy crap. I just saw your comment, Laura, and I tried to pin it, and it was moving too fast. Oh, yep. The Waukesha deputies were fine, though. They got some good-looking cops. That's what I said when they had that Waukesha standoff not too long ago. I was like, please don't let any of them pretty deputies get hurt. Are we going to see another black eye today? I don't know. Politics ruins everything, doesn't it? I know. Where is Kimmy? Oh, thank you, Tal. All the women in the chat are like, ooh, we got a new bailiff. Oh, y'all need to settle down. Turn the fans on. Get your hot flash fans out, ladies.
It's a day. It is a day. Yeah, okay. there and let them park the car, and then I'll deal with it.
We got 1,000 people in the live. Please hit the like button. Thank you so much.
Although I just got my vanity plate on my little convertible.
That's the CP century. That's how I got there.
But my vanity plate on the little convertible sidebar. It's a good light. Yeah.
He said his vanity plate was sidebar.
My other one's litigator. Yeah, that's my other plate. Yeah, that's the convertible. But I don't think that was you. Now, who's stealing my wheels? What's the safety on that? How about don't park your car with those stealing wheels?
The volume is super low because they're talking amongst themselves. They're not in the microphones or anything. So, oh, thank you, Miss Barbara. You're so sweet. Did I miss anybody else? Anything? If I did, I'm going to go back to it. Okay, guys?
Oh, it's a day, Shelley. It's a day.
Oh, Abellis, I just saw you. Okay, we're going to go. When this is over, I'm going to go back through y'all's super chats, okay? Thank you, Miss Barbara.
Matt, he was never out on, looks like he was never on bail in the intimidation case, was it?
Oh, they're talking about him.
But I don't know that he was, I don't think he has an independent credit because he probably had other.
Well, she runs a concurrent, he has credit.
Yeah.
So she had 50,000 cash on that one.
You think those are real dreads, y'all? He's trying to grow that hair back, that nasty hair.
You guys got room? Good.
State of Wisconsin versus Darrell Brooks, case number 21 CF 4596 and 21 CF 5020. Appearances, please.
Matthew Torbenson and Shelley Grosso appear for the state. Good afternoon, Your Honor.
Good afternoon.
Attorney Russell Jones, on behalf of Mr. Brooks, he's present, I'm present. Good afternoon, Judge.
Good afternoon. Hello, Mr. Brooks.
Hello, Judge.
All right, so we are here for a sentencing. I understand we needed to put something off because you had some surgery. I hope you're feeling better. We are now ready to proceed on this. The last time that we were in court, you entered a no contest plea and the court found you guilty in 21 CF 4596, count 3, second degree recklessly endangering safety with a domestic abuse assessment, and in 21 CF 5020 of count 1, intimidation of a victim by threatening force. Are we ready to proceed with sentencing from the state's perspective?
Yes.
All right, and from the defense?
Yes, Your Honor.
All right, I'll hear from you first, Mr. Torbenson.
With regards to victim notification, we notified Erika P. of today's date, these proceedings. We were hopeful that we'd have a victim impact statement from her for Your Honor. Unfortunately, there have been some recent political ads that have featured what happened out in Waukesha that have resulted in recurrent trauma for her. She has chosen not to be here today. She has chosen not to file the victim impact statement.
What?
I will hopefully relay to the court as best I can the impact that this has had on her, the enduring impact it has had. But she has made the choice, the conscious and deliberate choice not to be here today because of that.
All right, I appreciate your making that record.
I did file a documentation from Crime Victim Compensation for restitution.
I saw it, thank you.
When considering the serious nature of Mr. Brooks' offenses, Mr. Brooks' character, and the need to protect the public, the state is respectfully requesting that the court sentence Mr. Brooks to a substantial prison sentence in the Wisconsin state prison system. We are leaving the length of that substantial prison sentence up to the sound discretion of your honor. On November 2nd of 2021, Erika P. was staying in a hotel when she heard a knock on the door. She opened the door to find Mr. Brooks there, who was immediately argumentative with her, confronting her, took her cell phone away from her to prevent her from calling anyone for assistance or help. Erika left the apartment building and began walking down the street, and Mr. Brooks got into his red truck and followed. He would corner Erika at a gas station, get out of the truck, continue to argue with her, punch her in the face, resulting in a swollen eye, repeatedly attempt to get her inside of the vehicle. And then when she refused to get inside the vehicle, he would get inside of that truck and run her over. She suffered a dislocated femur, a fractured ankle. She had a swollen eye, she had cuts to her legs, and perhaps the most vivid picture taken by the Milwaukee Police Department is that of her pants, which show the tread marks from Mr. Brooks' tires, the tracks on her pants that had to be cut off her at the hospital so that she could be treated. That same day, November 2nd of 2021, there was a young prosecutor in the Milwaukee County DA's office. She was finishing a domestic violence felony jury trial. There was no victim that showed up for that trial, but she chose to go forward on it. She obtained 2 guilty verdicts from that case. That evening and the next coming days, after proceeding on a trial, she would review 22 domestic violence referrals, one of which was this case. She would reach out and try and make contact with Erika, and she couldn't get a hold of Erika. The allegations were so severe, so serious, that this young ADA chose and said, this case needs to be charged. Something needs to be done about this. So without victim input, this prosecutor issued charges of obstructing an officer, disorderly conduct, misdemeanor battery, and second-degree recklessly endangering safety, in part because we didn't have the medical records from Erika. Unknown to this prosecutor, unknown to the district attorney's office, was what Mr. Brooks was doing after he was apprehended and in the Milwaukee County Jail. One day after being apprehended and in custody, he would reach out and make a phone call and involve his own mother in intimidation. He would ask his own mother to reach out to Erika and tell her not to show up to court. That if she didn't show up or if she told them she was not going to cooperate, that the charges would get dropped altogether. One day later, on November 4th, he would make direct contact with Erika P. His words to her, "Why did you do this to me? You know I love you. Listen, listen, listen. I've come to the realization that I'm not going to leave you. You have my daughter. I know your potential. I know what you can be. I want to marry you. I'm not going to play anymore. Will you marry me?" And then the very next sentence, "Then you need to call them people," meaning you need to call the prosecutor, you need to call the district attorney's office, you need to make sure that these charges are dropped. 2 days after running over his girlfriend and the mother of his child, he's using emotional manipulation, promising a future, promising marriage, promising change, all in an effort to try and get Erika to drop the case. and the charges. And blaming her, telling her it was his fault she was facing, in his words, 60 fucking years. And telling her she should have kept her mouth shut. Telling her the pain it was going to cause his mother because she called the police and made a report. The tenor of those calls would change significantly from emotional manipulation and promises of a future to direct threats of violence. Telling Erika that he had people out in the street watching her, that if she moves, he could tell his people to move, that he could have her taken care of if she didn't make efforts to have the case dropped. Mr. Brooks is a really smart individual. He knew that her medical records would be crucial in this case. He told her not to sign a medical release. And that if she did not come to court, in his mind, there was no way that the state could prove the charges and the case would be dropped. But he would threaten her safety from the confines of the Milwaukee County Jail. Even in jail, even in custody, he showed the ability to threaten, to manipulate, and to control Erika. Mr. Brooks is the epitome of a domestic violence abuser. Someone who you even think when they have them locked up, they're offending and controlling. Unfortunately, none of that conduct was known at the time that Mr. Brooks was in the Milwaukee County Jail. It was discovered after the events took place out in Waukesha, and I'm going to talk about Waukesha little, if at all, today, because what we're here for is what he did to Erika in Milwaukee County. But after the events transpired in Waukesha County, investigators with the Milwaukee County District Attorney's Office went back and looked at his calls, and they found this intimidation, rampant intimidation, multiple calls taking place over a period of 10 days, all in an effort to ensure that she never came to court. All in an effort to try and escape his responsibility for his actions in battering and running her over. It wasn't just Erika who saw and experienced the defendant run her over on November 2nd, 2021. There was a citizen witness that saw it. That person certainly was traumatized what they observed, but they reported his deliberate actions in battering her and then running her over. This was not an accident, as Mr. Brooks would try and get Erika to portray. And so the offenses that this defendant committed in Milwaukee County are extraordinarily serious. They were life-threatening for Erika. They are life-altering for Erika. They were traumatizing for Erika. And then after the events of November 2nd, within the confines of the jail, he invades the province of this system a system where we rely on citizens to come into the courtroom, to take the stand under oath and to tell the truth. He did everything he could to prevent that from happening. All in an attempt to escape responsibility. For those actions, he is singly and solely responsible. When considering the defendant's record at the time that these offenses were committed, he had an open criminal case in Milwaukee County that was 2020 CF 2550. He was charged with 2 counts of second-degree recklessly endangering safety and felon in possession of a firearm. That was resolved with a charge of felon in possession of a firearm when the witnesses did not appear on the second-degree recklessly endangering safety. He pled to the felon in possession of a firearm charge to his credit. He was sentenced to 4 years in the Wisconsin State Prison System, 2 years initial confinement, 2 years extended supervision. In 2011 CM 6550, Mr. Brooks was charged with possession of a controlled substance, THC, and misdemeanor bail jumping. He received 180 days in the House of Corrections consecutive on each count. In 2011 CM 1812, he was charged with obstructing an officer. He was sentenced to 37 days in the House of Corrections. In 2011 CF 5366, he was charged with possession of a controlled substance, second or subsequent, received 180 days in the House of Corrections. In 2010 CF 87, a Wood County case, he was charged with strangulation. He received a probation sentence in that case. He was revoked on that probation. He had a withheld sentence during the subsequent sentencing hearing, who received 11 months in the House of Corrections.
Was that domestic violence related?
It's difficult to tell because it's not a Milwaukee County case, so there's not a lot of information that I could find on CCAP.
Just give me 1 second, I can look. You said Wood County?
Yes.
Thank you, Mark.
It does not appear to have the assessment, but the facts alleged in the criminal complaint do seem to indicate a personal relationship. Okay.
Yeah, my client indicates it doesn't qualify under the DV statute, but it was a personal relationship. I don't know that, but I'm just letting the court know.
Understood. I just read that, so it makes sense. Okay, go ahead.
In 2005 CM 151, a case out of Manitowoc County, he was sentenced to 10 days in the House of Corrections. It's a misdemeanor offense. Beyond that, I forgot to write down the charge. I apologize about that. I believe it is an obstructing an officer, if my memory serves correct. In 2002 CF 936, he was charged with possession of a controlled substance, second or subsequent, it was marijuana. He received a 50-day sentence in the House of Corrections. He has a 1999 felony charge in case ending 4470 for substantial battery. He received a probation sentence. He was revoked on that probation and subsequently sentenced to 2 years in the Wisconsin State Prison System. He also has a sexual assault conviction from January 3rd of 2007 out of the state of Nevada for statutory sexual seduction is the name of the charge.
Give me a second. That was the 99 case in Milwaukee?
Yes.
Obviously, everybody's watching me do this. I'm looking them up on CCAP on my judicial dashboard, which has a little bit more information than other people are afforded. it does not appear that that has anything to do with the substantial battery. It had nothing to do with any sort of personal relationship, domestic violence, or anything like that. Okay.
So that's Mr. Brooks' criminal record with regards to his character. With regards to Mr. Brooks' character, I do think it is a positive that he entered pleas in this particular case. At the point that Mr. Brooks entered pleas in this case, he had absolutely nothing to lose. He'd already been sentenced to hundreds and hundreds of years of time in the Wisconsin State prison system out in Waukesha. And so whatever happened on this case, from Mr. Brooks' perspective, his life has already been taken away in many aspects by the sentence out in that county. And I recognize that, and I give him credit for the fact that despite the sentence he received in Waukesha County, he came into court when the state was ready to proceed and chose to enter pleas in this case. And that's a sign of positive character. I give Mr. Brooks credit for that aspect in this particular case. Your Honor, with regards to the need to protect the public, the state does believe that a substantial prison sentence serves the interests of the public in this case. I'm asking the court to make it a consecutive sentence, even though the sentence out in Waukesha exists. And I'm asking the court to do so for two reasons. The first reason I'm asking the court to do so is because these were separate offenses involving separate conduct and they deserve separate punishment. That serves the interests of both specific deterrence and general deterrence. Specific deterrence and punishment for Mr. Brooks, general deterrence, so our larger community knows that when you commit separate acts, you're going to be held to account for those separate acts through the punishment. Understanding the sentence that was given out in Waukesha, I'm also asking the court to consider consecutive sentences for this reason. As a prosecutor and supervisor in the Milwaukee County District Attorney's Office, I have seen cases that decades ago have been overturned by the federal court system based on decisions regarding a person's choice to represent themselves. I am not second guessing anything that happened out in Waukesha. I'm not second guessing the timeline of events out in Waukesha, but I have concerns because Mr. Brooks' attorneys filed a motion to withdraw on September 22nd. They were allowed to withdraw on September 28th of 2022. The case proceeded to trial on October 3rd of 2022, just 5 days later. And I know from watching that case that Mr. Brooks, during the course of that trial, made some requests for standby counsel. I don't know how the federal courts will review that. I don't know how they will consider that. But I do know from the state's perspective that Mr. Brooks poses a danger. And because of that, I'm asking that these sentences be run consecutively. 10 years, other sentences Mr. Brooks is currently serving. Your Honor, for those reasons, the state is respectfully requesting that the court sentence Mr. Brooks to a substantial prison sentence, leaving the length to the sound discretion of Your Honor. The last thing I'll have the court look at are two photographs of Erika's pants that were cut off from that day, showing vividly what Mr. Brooks did with his automobile.
You've seen these, Mr. Jones?
Yes.
All right. I've taken a look. Thank you. Okay, go ahead, Mr. Jones.
Well, look, I mean, the elephant in the room is what? 6 life sentences in Waukesha, right? So when we look at this, I'm not saying this is an academic sentencing, but in a large part, it becomes academic in terms of the outcome for Mr. Brooks. But I think what's interesting, and I think the state fairly points out, that Mr. Brooks could have simply just had a trial, could have put the victim through more torment and torture throughout this case. And he didn't do that. He didn't do that, I think, because Mr. Brooks recognizes that these circumstances warranted him to plead guilty. Now, look, the maximum possible penalty for the court here is 10 years in, 10 years out. And I don't think a max is warranted here. I think if we looked at this case in isolation and we didn't have the Waukesha case, we'd be arguing something very different. But we do have that, and that's certainly a backdrop the court gets to consider and quite frankly should consider. But when we look at those things, I don't think these facts, setting aside Waukesha, warrants the max penalty. I don't think his criminal history prior to Waukesha, which of course these instances predate the Waukesha incident, warrant a maximum sentence. So then the question is, what do we do? Well, first of all, from an academic standpoint, we have 946 days credit on the intimidation. We have 1,008 days credit on the underlying case. 18 days of those are completely independent credit, even if you run it consecutive. In other words, from November 2nd, 2021 to November 19th, 2021, he was in on just this matter, or strike that, on just 4596, which is 18 days. He then went back in on December 20th, 2021 through today's date, which adds another 990. By my math, that's 1,008 days total. And I'm just putting that in the right spot. Then he has the 946. If you run the two consecutive, then I guess you would subsume 1,008 days on the one and then not on the other. But that's what the numbers compute to with respect to credit. With respect to this incident, yeah, it's certainly not a case where I think probation's appropriate. Obviously, you got to consider that. I think that's easily dismissed given the seriousness of the crime. I don't think Mr. Brooks would even think that this is a probation case. But I don't think it warrants the maximum. What I'm going to propose the court do is I'm going to propose the court do 4 years in and 4 years out on each case, but I think that the court run them concurrent. So that's close to the maximum on each one. I'm asking the court to run them concurrent. The intimidation, even though it's phone calls, I don't think it's of the most egregious nature of an intimidation that we've seen come through these courts. There wasn't any sort of external efforts to physically thwart the witness, or some of the times when we see those efforts, these were phone calls. I understand the state views them all clearly as manipulation, but again, they're not at the high end of the scale when we look at those types of cases. When we look at the underlying case, that one I think has some aggravating factors, and that's why I think close to the maximum is warranted of 4 in and 4 out. I think concurrent makes sense. I think running a concurrent to the Waukesha case makes sense. And I think even if you run the sentences concurrent, despite the potential concerns the state may have, and I have no idea what's going to happen in his appeals, whether they are in state court or in federal court, I don't think really this court should speculate on that. I don't think that's the issue that this court's dealing with. The issue this court's dealing with is, how do we sentence somebody under these circumstances with the character of this defendant, with the sentencing factors in this case? And that goes to the seriousness of the crime, the need to protect the community, and then of course his character. When we look at that in isolation, and I understand that's difficult to do, I think a sentence that is near the maximum is appropriate of the 4 in, 4 out on the underlying case. On the felony intimidation, I think running it concurrent makes sense. I think if this was an isolated case, it very well would be running concurrent, or at least likely could run concurrent. And so I don't think that we need to pile on top of that. I mean, at the end of the day, he has 6 life sentences in Waukesha plus. And I understand largely this might be academic, but I think that when we try and isolate each individual case for a sentencing, which we're supposed to do, that's the right sentence for this case under these facts with this defendant. And I'd ask the court to follow that recommendation.
All right, thank you. Mr. Brooks, what would you like to tell me?
First, I just want to thank you for how you've handled this case. It's been three long years that I've been coming before you now, and just want to tell you that throughout these 3 years, this matter has affected the people that matter most to me. namely my children too have been affected by this. It's kind of like a, a rift. This situation happened with, the mother of one of my children. And, coming from a broken home myself with those types of issues that, my mom went through, I think I have a better understanding at this point now of the way that these can affect kids growing up. I want to say that I take responsibility for my actions fully. I'm not gonna hide behind anything. I'm a man up. And in these years, I've made the choice to look at those things and decide for myself that the cycle stops with me. I have 2 sons, and I definitely wouldn't want them to be involved in anything that would hurt people they love, or, when they have children, for their children to be hurt in those ways as well. So that's part of the reflection that I've been doing. I've also, well, it's been difficult because of my situation in prison to actually get things done because of my custody status, but I've taken the initiative to program in those areas, dealing with domestic violence issues, childhood trauma issues, things of that nature. I'm doing fairly well with those, which is something I never had, growing up. And, just to have the opportunity to look at better ways to deal with frustration, deal with anger, to deal with understanding. I do also want to say for the record that this is the only type of domestic violence issue that I've had that was any type of personal relationship, and from the aspect of someone that I have a child with.
Okay.
Yeah, from that aspect.
The Wood County person was a personal relationship, but you did not have children, correct?
It was not somebody I knew very well. It wasn't a relationship. It wasn't a romantic relationship type of thing. Yeah, I'm sorry about that. We did know each other, not very well, and there was no romantic connection with that situation. But like I said, Your Honor, in these 3 years, it's about trying to do what you can to, progress and move forward. And the biggest thing for me at this point is, to move forward. I obviously can't, change the past at this point. People will see me how they will see me. I accept that, But I do want to say that outside of my other matter, I just want to not have the weight of that so much be the narrative in this. You know, the whole time I've been coming before you, I think there was some concern about how I would present myself. I made it my point to show you that this wasn't gonna be more of the same. I've done my best to make sure that I've respected Your Honor and, you know, your court and everything like that, and to try to show the growth that I have been working on in these few years. And I guess to show more a different side of me, more a side that I'm moving towards, the side that I'm on the path towards. And, you know, and that was a goal of mine, to make sure that I didn't make your job harder than it needed to be. And outside of that, I just, you know, want to set my other matter to the side and just be fairly judged on this. You know, and that's why I thank you for the way that you've handled it this entire time, because I can bet you probably like, why is this guy still on my docket at this point? We should have been past this by now. But I think the length of the matter to my favor gave you more of an opportunity to see, like, you know, this is the road I'm going down now. And unfortunately, my situation is what it is. But I know I'm on the right path.
Thank you for your comments. So whenever I sentence anyone, I need to consider three separate things: the gravity of the offense, the protection of the community, and the character of the defendant. To address your kind of last point first, I live in the world. I know what happened out west of here. But from the very first appearance you made in front of me, that was after that, you have not been the person that we saw on TV that was there. You have acted absolutely perfectly fine in this court, and I want you to know that I appreciate it. There are security measures that are in place with the sheriff's department based on those issues, but you have never acted up in court. You have never been disrespectful. You have never done anything. You are an absolutely different person as you deal with this court than you were as portrayed out there. And I recognize that, I appreciate that, and I absolutely am separating these issues. These incidents, the initial incident and the intimidation that took place thereafter, took place prior to what happened in Waukesha, and you will be sentenced simply on those. I don't ignore them, they exist, but you have, it is not my issue, that is their issue. So, having said that, I am extremely pleased in what you have demonstrated over these past 3 years with me, because I believe that you are on the path that you say that you are. Russ, can you get him tissue for Mr. Torbenson? You have an empty box in front of you, I believe.
Oh my word.
The problem is, as I have to sentence you for these offenses, I have to look at your behavior for these offenses. I have a question for you before I get to my comments from that. In looking at your record, something jumps out at me. You have a number of offenses starting in 1999, all the way up to 2011. Some gaps. What happened? What were you doing between 2011 and 2020? Did you live here? Did you live somewhere else? You don't seem to have any criminal contact. What were you doing?
I did live out on the West Coast.
Is that when you had that was a 2007 Nevada case? Were you in trouble out there, or were you living a...
No, I was thriving, Your Honor. I was thriving. I was working. Had a great relationship with my children.
How old are your children?
21, 17, 13, and my youngest daughter just turned 10 last week.
Which is the one that you shared with EP?
My 17-year-old daughter, who was starting to spell me college. And I'm missing it.
Well, you are. But
I'm
that's
so proud of her.
That is an amazing accomplishment. I'm glad to hear that.
She graduated a year early because her academics was so up to par. I didn't get the chance to see her walk across the stage.
She sounds extraordinary. All right. So you were doing well. Right up until you weren't. So looking at this, it strikes me that you don't have a relationship that goes on for 17 years, or roughly about thereabouts. And the very first incident of violence between the two of you results in you following her to a hotel, banging on her door, and when she tries to get away from you, following her, cornering her, punching her in the face, and ultimately running her over. That was absolutely outrageous. And you are so very lucky that it was her leg versus her torso or her head, which would have killed her likely. Your behavior was so outrageous that it can't be downplayed. And I look at that in isolation. I look at that as this is someone whom you've had a long relationship with, whom you have created a child, and you disposed of her as if she were roadkill. And that behavior by itself is outrageous. Then you factor in the intimidation. The quotes from that those jail calls, not the usual. Unfortunately, I've seen a lot of intimidating jail calls that involve, let's be together. If you want us to be together, you have to get this drop so we can be together. And I can show you how very much I love. I've heard that a million times on jail calls. But when that didn't seem to work, you doubled down and intimidated her in such a manner. Mr. Jones may say it's not the worst because there wasn't any follow through, that nobody followed her from her house to court on the day she was supposed to come and testify and ran her off the road or did any of those things. Of course that could have happened, but we were 10 days out from the incident. There was no trial at that point. Who knows what may have happened at some point. This is the very first part where the only thing you're in control of is trying to get her to call the police, call the DA's office and say, I'm not in, I'm not prosecuting. So that was what you had at your disposal, was just to so berate her and so humiliate her and scare her. So as to get her to do your bidding. Because you're locked up, right? So you can't get her. But what you did was you told her, I got guys. I got guys who are going to get you. The minute you walk out your house, they're going to get you. If I wanted you dead, I'd kill you. You'd be dead. That is a horrible, horrible way to live. Because she may have 99% thought you were full of it. But that 1%, when she hears a noise in the house, or sends your daughter off to school, and your daughter in high school, half an hour late, coming home from school, talking with her friends, busy, whatever. And what does that do to EP? Oh my God. Did someone grab her? Is this it? Did he call his guys? Because I didn't do his bidding fast enough. That's absolutely horrendous behavior. And it is who you were. It's who you demonstrated yourself to be. Whether that was the full content of your character, I can't speak to. But on those days, that's who you demonstrated yourself to be. I very much hope that you are on the path that you described. Because you likely have a very long life ahead of you. You spoke to your prisons, your custody status. Are you held in segregation? Are you by yourself? What goes on there?
Housed in, say,
You are.
yes.
I appreciate the efforts that you're undertaking to better yourself, to say, this is not okay. And I've got to figure out why I thought it was. And if that is going to come through classes or anger management or reflection, as you put it, all the better. I have no idea, nor am I considering what's going to happen with appeals and all of that sort of thing. But you have to live with yourself. And getting right with yourself is going to serve you as well as humanity. So, the first thing, as Mr. Jones mentioned, is that I need to consider whether probation is appropriate. No one's asking for probation. Probation is not at all appropriate here. So I reject that. So this will be a prison sentence. You asked, and I promised that I would take this as it was for itself, and I will. This incident happened before Waukesha, and I don't mean to, by any sense, give short shrift to what happened there, but this is what is before this court. So I do believe that this is a prison sentence. I also adopt the state's theory of these are separate acts. Your behavior in what happened at that hotel and then following her to the gas station and running her over was one day. And then you came to jail, not in the situation any further, not faced with her, not presumably in the midst of anger. You may have been angry about a variety of things, but not in a face-to-face, we're having an argument, anger. And you opted to violate the court's orders by contacting her, by contacting your mother and putting her in the middle of everything, and contacting EP directly and saying the things that you said, which were horrible. And I suspect she will never forget them. Because after a relationship of that length, you may be a voice that is in her head. And I'm very sorry for her for that. Conditions of time that you are serving will include absolutely, positively no contact with EP. You have said that your child with EP is 17 years old. The state is not seeking a no contact order with her, are you? With the child?
No.
No, I'm not going to do that. She's about to start college. She will be in charge of whether there will be any contact. There is a request for restitution. Have you gone over that, Mr. Jones?
There's a stipulation on that.
Okay. Restitution in the amount of $656.96 will be made payable to the Crime Victim Compensation Program. You will have to pay the DNA surcharge as well as the domestic abuse assessment and any mandatory costs, fees, and assessments. I'm going to waive any non-mandatory. You don't have the ability to pay any more than you are going to have to pay. So I will waive those due to your inability to pay. What I have ordered will be due and payable from your prison funds at a rate to be determined by the Department of Corrections, then will be payable as part of any sort of extended supervision that you're released on,
And if you are, if it's not paid by the end of extended supervision, it will convert to a civil judgment. You are now a convicted felon. You may not possess any firearms. You cannot vote until your civil rights are restored. This was a violent felony, so you may not possess body armor. And if you violate that no contact order, you could face additional charges. I am going to order strike that. Encourage you. And I say this because of your custody status. I'm going to encourage you to participate in any sort of programming that is available to you. I'm not ordering it because it may conflict directly with your custody situation. And I don't want to put you in a situation where you cannot do something that I've ordered because of your custody situation. So I'm going to encourage you to take domestic violence intervention programming, anger management, and individual therapy. Whether that will be made available to you as part of your prison sentence, I don't know. If for some reason,
I would do my part to find out. So
I know you will. If for some reason you are released on extended supervision on this case and released into the community, those will revert to being suggestions to orders. Okay?
Yes, ma'am.
So if you're released, they will be court orders then, if you have not already completed them in your prison setting. So now we need to turn to the amount of the sentence. As Mr. Jones noted, this was punishable by the possibility of $10 initial confinement and 10 years extended supervision as totals, if I ran them consecutively. I do give you credit for entering no contest pleas to these charges and not putting EP through a trial. I do take into account the entirety of your situation. Therefore, I am going to sentence you as follows. On 21 CF 4596, count 3, the second degree recklessly endangering safety with the domestic abuse enhancement, I will sentence you to 9 years in the Wisconsin State Prison, 4 years and 6 months initial confinement, and 4 years and 6 months extended supervision. On 21 CF 5020, count 1, the intimidation of a witness, I will sentence you to 9 years in the Wisconsin State Prison, 4 years and 6 months initial confinement, and 4 years and 6 months extended supervision. Those counts will be consecutive to one another because they were decisions made on different days. You made volitional decisions to engage in that behavior on separate days. And it will also be consecutive to any sentences that you are serving from any other jurisdiction. That is the judgment of the court. You do have the right to appeal my sentence, and Mr. Jones will go through those rights with you. I wish you well, Mr. Brooks.
Judge, the credit.
He does not have credit given the way
Well,
that I've
he would have
structured. Oh, 18 days credit on,
4596.
yep, 21 CF 4596. 18 days independent credit on that one.
Because she ran a consecutive. Because she ran a consecutive.
No, it doesn't, but I have to mark something. Oh, I have found, based upon the seriousness of these crimes and the way that I have structured the sentence, as well as the entirety of the situation, that you are not eligible for the challenge incarceration program or the substance abuse program.
So, Judge, it's the court's position that the 990 days from December 20th through today's date, he does not get because he has those on the Waukesha case, given that it's consecutive, correct?
I believe so, yes.
That's your order.
Yeah.
So I'm a little confused, Your Honor.
You were held on bail on those cases, on the Waukesha cases, because you were sentenced there first. Presumably you got sentence credit on those. If I'm wrong on that, your post-conviction attorneys will file a motion.
Okay.
But because of the way I have structured them, that it's consecutive to those, you don't get credit twice. So I think you got credit in Waukesha, so I don't give you credit now because one comes after the other.
Oh, because
Since the 18 days.
What?
I think I was,
Except for the 18 days when you were held between the time you were arrested and you bailed out.
oh,
She's calling the DOCO correct.
yeah, because I was thinking about the 973-155 statute. That's the way I looked at the time served. The Wisconsin statute 973-155, 1 in subsection A.
Okay, I appreciate your position. I disagree. So if there's a post-conviction problem, your attorney can file a motion. Okay? All right. Good luck.
Just so you know, I filed it all already. I filed all your post-conviction already. Okay.
Oh, y'all don't talk politics in the chat, please. Please don't do that. Has nothing to do with it. It's disrespectful to the victims in Waukesha.
Yep.
I'm just a little confused.
Oh, he's still. No, he's still.
Bye, Darrell.
Yeah, he was caught. Yeah.
And I'll say it for J9 since she's not here. Okay. Mama loves you. Oh, he's disgusting. Just disgusting. Okay, so you know what? I was thinking that when his attorney came up, I was like, he sounded like a cell on Friends. He's like, well, we got to look at the elephant in the room, Judge. You know, the 6 life sentences. I think we all need a good shower after that. I don't know about you guys. I just want to go back to some of the things that he said because I was screaming and I was putting it into my pen and writing it all out here. No, he didn't apologize to Erika, did he, JPC? Good, great point. He never apologized to her. He said, I'm going to man up. Once again, he says that. And he was talking about, I'm going to end the cycle here with me, talking about the DV and his family. And I'm thinking, you didn't have any choice but to end the cycle, you fool. The law stopped you from continuing that cycle. You didn't make that decision, not for anybody. And then he said he's taken the initiative to take DV classes and child trauma classes. Come on, you lying. He did that to pass time. He's not doing anything, but he's a lying pack of poo. That's all he is. For the record, he said, and for the record, he said that one last time. This is the only time that I've had a domestic violence with somebody that was my kid. You know, those other DVs I had, well, they were not romantic. Like that freaking mattered. You hit women. You're a monster. He doesn't want any weight on his shoulders. he had a goal to help the judge not make her decision any harder. So he's tried really hard, because there was that other matter. He can't even say Waukesha Parade, other matter. And then he had the nerve to say something about the road he's going down now. I really want him to take those thoughts, those sentences of the roads that he's traveling out of his vocabulary, because he has all that does is slap. I do need a big drink. I need a mega pint. All he does is slap the Waukesha victims in the face every time he makes those comments. Now, she had to separate his Waukesha crime from this, you guys. And I know it's irritating and we were getting upset about it, and I was too. But I mean, as a judge, that's why they call them judges. They have to be fair and balanced. And they have to say, okay, this is this case only, because you've already been sentenced on this other case. But she didn't have to give him so many dad blasted compliments. That just made me irritated. Now, with that being said, she could have given him 10 years and 10 and 10, and she only knocked off a year on each one. So that wasn't really that bad. I mean, let's face it, we know this is like a backup plan. We don't think his appeal is going anywhere. In fact, we're pretty certain it's not going to go anywhere. So this was like plan B. If he ever got out of that, he'd still be in there for a good 18 years at least, right? All right. This is horrible. Thank you, Tracy Daniels. I got to get to my super chats and let everybody say thank you to everybody. Do you know how much his commissary money he will actually receive? I hope it takes him a month to get enough to buy Snickers. Hopefully they don't even have Snickers in the commissary. Hopefully all they have are those crappy little Debbie cakes that are stale. But what was it 25%? He could only get 25% of what he earns or something like that. Am I right? Somebody knows that in the chat. I can't remember what it was, but I believe it was only like it was a very small amount, and the rest he had to pay to restitution and paid to the families of the victims. Don't be talking about suitcases. Mark, you're such a crazy. Thank you, Tracy, for that super chat. But yeah, let's see if somebody says it. Come on, y'all. Who knows this? Amanda, you know this. What is his... I want to say it was 25%. Yes, fan lady. Thank you. 25%. So he can only get 25%. She knows that his money's no good because nobody's ever going to see hardly any of his money. What does he make in jail? Pennies? Change? Thank you, police wife Amy. And thank you for your husband's service. We appreciate you and him. Thank you so much. I appreciate that. Let me go back over here to the other ones that we had here. That I didn't get to say anything about when we were in the thing. Zephyr. Thank you, Zephyr. You're so kind. And thank you for being a member for 12 months, honey. Love you, girl. And then also Miss Barbara. Miss Barbara's like my cheerleader. She's so sweet. Welcome to all 12K and going to be the best chat on YouTube. Yeah, we hit 12K subs. Yay. Yay me. Yay us. We are a community here. I appreciate you guys for sticking with me. Because it's been a long 2 years, 3 years. And Bella, I wanted to say welcome in. For those of you guys this is your first time here, thanks for joining us. We do have a really nice community here. We're very kind to one another. And we stay away from politics and all that. So we can just talk about true crime. So welcome in if this is your first time. Naomi, I think your chat was probably the chat of the day. She said, did they surgically remove his narcissism? That was awesome. Now, somebody in the chat did say that his surgery had to do with some kind of oral surgery. That was all it was. But he milked that shit for everything he could. Oh, God, it's maybe his teeth are falling out. His gold grills. Please. His gold grills were about as fake as his dollar store dreadlocks. And Patty, and I love how Patty says it, just like we're all thinking it. He took that plea because he got his butt kicked in county. He didn't take it for Erika. He didn't take it for anybody else. He took it for himself. Thank you, Barbara. Yeah, we do try to be. This is a safe space. This is a safe space for people. Thank you, Mark, for your 5 gifts. That is so kind of you. Still gifting out people. Mark gifts about, I think, almost every chat. So thank you so much. Every live we do. He's been hitting the casinos hard, you guys. He's winning money. When you come down here, Mark, when you come over here to the Biloxi area near me, we're going to go to the casinos together. Miss Barbara Seals also gifted 5 memberships. Thank you. And welcome to those who got the new memberships. Abellis gifted 5 memberships. Thank you so much. I appreciate you guys. And you gave a super chat. Carrie, your dog could have kennel cough. It's very contagious among dogs. I know, but I don't think that's what it is, though, because he's not been around any other dogs. We pretty much stick to ourselves. I don't take him out anywhere. He doesn't like to car ride. He does not like to get in the car at all. And we live in a really big private area, like we're out in the woods. So he doesn't run into too many other dogs. And he doesn't like other dogs. Thank you, Mel, for your gifted memberships. I appreciate you. Thank you, Joe Cognick, for your super chat. And you're welcome. JPC's been a member for 17 months. She's a big old OG. See, that's how not cool I am. I just showed my not coolness there. Barbara, another super sticker. My goodness, Barbara. She's going crazy with the buttons today. And Lariah, I hope I didn't say your name wrong. Welcome to the crew. We appreciate you guys so, so much. Okay, so I have a surprise for y'all. There's over 1,000 people in here right now. We can't not get together like this for the final Brooksaholics Anonymous meeting and not watch some clips of the trial. What do y'all think? I'm cool with a KEWL. All right, so let's do, this is probably my most liked video I ever did where I put these together. So let's do this. Box fort. Go ahead and put your one-liners in the chat. Back for another day here with the Darrell Brooks trial. The trial that never ends. The trial that we can't seem to get enough of. And why can we not get enough of it? Well, this is why.
And just for the record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I can't even get these admitted into evidence.
For the record,
All right.
I didn't bring up the word
Let
violated.
us continue then. We're going to move on, Mr. Brooks. Let us continue with the
So we're gonna
questioning
move on to
of.
subject matter jurisdiction that
No,
has
I'm
yet
not.
to be proven?
Detective Carpenter, you can please come on back up to the witness stand, and Madam Clerk, you can have the jurors brought out.
So we're not gonna address that at all? That's not gonna be proven for the record? Is that a judicial determination that you don't have to answer the question, Your Honor? Is that also a tactic agreement?
Continue to interrupt. You risk forfeiting your right to be present in this courtroom.
Your Honor, may I see a sworn affidavit of the nature and authority of the court? Grounds. I hope the record reflects that.
Do you have any objection to Exhibit 82?
Yeah, I got objection.
What's the objection, sir?
What is the relevancy of Exhibit 82?
82 is your interview with Detective Carpenter and Detective Stern. I will not have you claim legitimacy for what are debunked, frivolous, sovereign arguments.
Are you aware of who the plaintiff is in this matter?
Objection relevance.
Grounds. We're not going to address that either. That's still not going to be proven, right?
And did you notice anything different about your surroundings as you heard the screaming?
Objection. I asked the form of that question and it was answered.
Overruled, he may answer.
Can you just repeat the question, please?
Sure. Do you notice anything other than the screaming that seemed unusual when that happened?
Objection, different question.
Overruled. Not sure what the objection is, but you may answer.
Can you just repeat the question, please?
That's Mr. Brooks. I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand.
I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom?
I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Record to reflect, he's holding up his objection sign. It appears that he's writing, I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements? That's not how it was said.
That was how I said. You want to run the record back?
And you're
Nice try,
see-through.
but I see through it.
So,
With all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted. And again, I believe you're questioning him about legal issues that aren't relevant, but you're the proponent. You want to question him. What's the legal basis you believe I should allow you to continue with that?
What legal basis are you referring to?
Can the Title IX please direct the prosecutor to answer whether their assessment for the charges
Mr. Brooks,
in her possession?
no one's going to be answering these questions, okay?
Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven?
I'm tired of being in the courtroom that has no integrity whatsoever.
Your Honor,
That's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case as your own attorney.
To represent myself pro per.
At that time, were you provided the complaint in this issue?
Your Honor, I do not agree to it.
The record to reflect.
Reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So I'm not hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the people?
You're assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir.
I don't consent to this.
First of all, I accept for value in return for value this paperwork. Don't I have rights though, Your Honor? I don't understand anything, and I accept for value in return for value this document.
Information and all documents in this case. Your objection is noted. It does not need to be repeated. Thank you. Mr. Brooks.
I have a right to be present for trial.
Are you aware that I don't identify by that name?
Welcome, everyone. My name is Carrie, and it is Friday, and it's time for another edition of a Scrappy Doo Brooks court compilation. We hope you are ready. We thank you for joining us. Sometimes he's so irritating, it's funny. Sometimes he's so dumb, it's funny. Most of the time, though, he's just irritating.
I don't understand the jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participating in something that I don't understand.
Provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I'm here concerning this matter as third-party intervener.
I don't know if the mics are on.
It should be, yes.
Okay. I'm soft-spoken, I'm sorry.
Said no one ever.
Sorry. So
Nobody reported on record about me being bruised up and having to get bandaged up.
Was not.
And I would like the record to reflect that you have not shown verified proof of subject matter jurisdiction whatsoever. And that by refusing to answer, that is a tacit agreement by you, Your Honor, which you understand what that means. I know you do.
Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
You interrupt, you don't wait for anyone to finish.
Don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party intervener on special appearance on behalf of my client. Can that be noted for the record?
Was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
I'll make a finding that he's forfeiting his right to be present in this
I didn't forfeit
courtroom.
anything. I asked.
Let the jury know that when they come
So
in.
are
Yes.
you overruling the fact that the true nature and cause has not been presented to me, that I don't know what the true nature and cause of the charges are? Grounds for the sustain, Your Honor.
Next question.
So I can't get no grounds. Okay. I'm not making a voluntary waivery of anything.
So there'd been the subpoena sheet that would have had, your name and a number of different.
What do you mean my name? What are you referring to?
I believe it would have said Darrell Brooks on it.
Are you aware that I don't identify by that name?
Objection, argument
Sustained.
Sorry.
Are you willing to expressly waive that right on the record right now?
I'm not gonna expressively waive anything.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want. I need to make an appropriate record.
I just told you that I don't understand the questions you're asking. What do you want me to do? You seem like the same thing that was there yesterday.
It's not. There are some changes.
What changes? It's the same document. That was accepted for value, returned for value yesterday. The same document. Now please go back into the other courtroom. Not allowed to.
Not now. The jury is in this courtroom and you will show respect for them and for this court. Sorry, is there an objection?
Yes.
The basis of the objection?
Relevancy.
It is relevant. It is received, 51B.
Objection be noted for the record, Your Honor.
It already has been.
I can't answer something I don't understand.
I believe you're choosing not to answer them.
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so.
I want to
Stop interrupting me.
You were quiet. I didn't.
Mr. Brooks,
Respect for them would be
Mr. Brooks,
telling them the truth.
stop. All right. Bring the jury in, Madam Clerk.
And I object to that.
To the timing?
Yes. It is my right to do so or to not do so.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
It is frivolous, though.
That's gonna get pressed every time. So I've yet to prove subject matter jurisdiction, any jurisdiction at all, right?
The jury will disregard the comments being made by Mr. Brooks at this time. They are a mischaracterization of the law.
Absolutely not. They are absolutely not.
you. I don't understand.
All right? You willingly waived your right to an attorney. I made all of those findings, so we will go
You made
forward.
those findings.
I am not obligated to answer questions.
You made
When you
those
ask me
filings.
questions, I'm going to mute him.
Hi, everyone. Welcome in. My name's Carrie, and this is a pre-recorded premiere of Mr. Darrell Brooks, the Waukesha parade attacker, who decides to call up some of his own witnesses that did not help him at all. In fact, most of them hurt him. And I put together a little compilation here of their responses to his repetitive questions. And I've even added some bonus at the end of how the prosecution gets up and just slams that door on it all. And the beauty of it is if you watched on one of my first videos that I ever posted about this trial, I trimmed it as much as I possibly could, but I wanted to show everybody all the steps that the judge went through to make sure that this guy understood that if he acted as his own defense, what he was up against, what it meant, where he'd be in all of this. And she went through every single thing with him. And he still wanted to come back and say that she didn't tell him everything, but it doesn't matter. She did. He's now defending himself. He doesn't know. He doesn't have a clue. He does not have a clue what he's doing. And with that, let's get to the video.
The defense may call its next witness.
Who's here?
Bertram, Hayes, Eldridge, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Eldridge and Lescano.
What did you see?
Besides the parade?
Yeah, I'm sorry. That was unusual. They caught your eye that evening.
Well, where we were, yes, a red truck came through where we were. It honked and swerved.
Do you recall telling her there's a shooting?
Possibly.
I'm assuming at some point your attention got drawn to something happening. That be fair to say?
Not necessarily.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
Your Honor, I object. Well, I realize there's no question at this point, but if he's going to ask the witness to answer his prior question, now that he's clarified, this is irrelevant question.
Do you recall?
I just answered that.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Do you recall stating that the other two were described as running in a westerly direction from the rear of 338 Maple Street?
No.
What were you doing that evening?
Went to the parade?
Was relevant. He said what was on his
No,
subpoena.
you've talked at length about the subpoena. So under 90611, move on to a new topic, please.
So what changed for the last question that you needed to?
I don't understand your questioning.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
Did you get a description of who was driving the vehicle you saw that day?
I did not.
Did you get a license plate?
I did not.
Do you recall if the vehicle had any tinted windows?
No.
Do you recall who served you the subpoena?
Objection relevant.
Grounds.
Overruled. The witness may answer.
The district attorney's office from Waukesha.
Do you recall if it was a specific district attorney?
I do not recall.
Did you see anyone else in the vehicle?
No.
And do you recall being informed that it was a possibility that you would be testifying in this matter?
No, I did not know that.
If he would like to call the DCI agent, then he may do so.
Grounds. Do you recall the gist of what you prepared?
Can you be more specific?
So why not be very confident the first time the question was asked? Grounds. Grounds.
And did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
That question wasn't answered, but okay. So what other details do you not recall?
You're under, how does someone recall the details that they don't recall?
Yeah, that's what I wanted.
Sustained as to the form of the question.
Seems very funny. Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have had clipped me or the two people that were in front of me.
But you do recall seeing the operator wearing a black sweater?
I don't remember.
And how many people did you see in the vehicle?
Just one, the driver.
So, do you recall flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
The evening of November 21st, 2021, you recall that evening pretty well?
Fairly well, yes.
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds.
Oh, this answer may stand.
That you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
Honked and swerved?
Yes.
What did it swerve from?
I'm sorry?
What did it swerve from?
Where?
The one that you received from the district attorney's office in July didn't have a case caption on it?
Okay, what's a case caption?
So, to your recollection, The SUV that you saw, did it have tinted windows?
I don't remember.
So, well, before we get to that, did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main East, the same route the parade went.
Sir, in July, when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection, relevance.
Grounds.
Sustained. Not relevant.
She's testifying in the trial, and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
And do you remember what the description was that evening that you gave to law enforcement?
No, I'm told it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
And did you see the vehicle stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop, no. It kept going through the parade.
And I'm assuming at some point you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did, by a detective.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for
relevant.
sustained.
It's not relevant.
I've never heard of nobody testifying in a trial that they didn't know who the trial was for.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is. Do you recall having a conversation with the plaintiff?
Objection.
Grounds.
Misleading, legally inaccurate statement.
Grounds.
Sustained as to the form of the question.
Which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him.
Or was it, I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
Objection.
Grounds.
Okay, so first of all, the
Grounds.
grounds are relevancy. It's not relevant. That would be the
You
grounds.
also have to state the grounds.
Hold on, let her get her position out, Mr. Brooks.
And it mischaracterizes the former testimony.
Sustained as to both grounds.
Your Honor, with all due respect, that's every question that I'm asking is relevant. It pertains to the plaintiff in this matter that seems to be nowhere
Mr. Brooks, we're
found.
making a legal argument. We'll take that up outside the presence of the jury. Move on.
I believe the jury deserves to know who the plaintiff is in this matter. That's very relevant to the case. How can they rule on something when they don't
Mr.
even know
Brooks?
who the plaintiff is?
Please, move on.
And do you recall about how long ago you received that subpoena?
Several weeks ago.
So pretty recent, would be fair to say.
Yes, I would. Well, several weeks ago. I'm not sure if that's your definition of recent or not.
Ask a question, or I will declare the examination by you to be ended.
It's not an examination, it's direct.
It's a direct examination, sir.
Just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't remember that good.
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again. Do you recall having a phone conversation with the plaintiff in these
Same objection.
grounds?
Sustained as to the form of the question.
Do you yourself recall reaching out to the plaintiff in this matter?
I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
Do you recall stating that it humped several times?
I don't recall.
When you were initially,
I don't recall.
you're recalling what you want to recall and purposely not.
Objection, badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall why that would be reported?
No.
What does that consist of? What are their resources in pursuant to the complaint that you filed or claim that you filed, right?
Can you rephrase?
Do you recall why the report says that you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Please ask your question again so that I'm clear.
Have you yourself ever reached out to the plaintiff in this matter?
And my objection is it's vague and it's legally inaccurate.
Sustained as to the form of the question.
So it'd be fair to say that you spoke with 2 different law enforcement officers that evening. Do you even know if there's a plaintiff in this matter?
Objection,
Grounds.
argumentative.
Sustained as to the form of the question.
Do you recall in your interview with Detective Coates in reference to the vehicle that you saw that evening? Do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
No further questions?
Any redirect?
No, Your Honor, I'd ask Mr. Schloman be excused.
All right, thank you, sir. You may step down. And he is excused.
State will call Robert Stone.
Do you recall in your interview with Detective Coates that evening stating that you could not provide any description of the occupants other than that they appeared to be African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there.
While at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that. I saw the driver going by because he hit somebody right in front of us.
And during that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming the individuals that you saw standing shoulder to shoulder was a older male?
I don't remember.
Any reason why multiple, well, I'm not gonna say multiple, two. Any reason why the two detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
No.
No further questions at this time.
Thank you, any cross?
Yes, Your Honor, thank you. Good afternoon, Mr. Lescano.
Good afternoon.
Sir, you said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade?
Yeah.
Yes. Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection, leading.
Overrule, it's cross.
No,
Speculative. Objection.
Overrule, the witness may answer. I believe he said no. His answer may
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection, speculative.
Overrule.
About how many people did you see the SUV strike, sir?
Objection, speculative.
Overrule.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in the air.
You remember that?
Yeah, it was right in front of us.
Okay. So, Mr. Lescano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65.
Go ahead.
Objection to the relevancy of Exhibit 65.
Noted, overruled. It's been received. The state may proceed.
All right. This total clip is 36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's shown in this picture?
Yeah, I believe that's Central Middle School.
Where?
Right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection,
Okay.
speculative.
Overruled. His answer may stand. He said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection, leading.
Overruled. You may answer.
Yes.
That looks right, correct, sir?
Objection, leading.
Overruled.
All right, we're gonna clear the screen, please, and we're gonna play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular witness.
Overruled. You may play the clip.
Overruled on what grounds, Your Honor? Is that attacking agreement?
Sir, did you see yourself or your family in that clip?
Objection, speculative.
Overruled.
No, I did not.
Okay. Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection, mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection. Stated it was black males. Asked and answered.
Overruled, the witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Okay.
And then on the porch, there was maybe 3 or 4 or more people. I don't know if they were, I'm sure they were white, but I was trying to not make it obvious at the time. I believe that they were with the vehicle, so I didn't want them to see that I saw them, so I just did what I thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection. Speculative.
Overruled.
No, I do not.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection. There was never any crash mentioned.
I'll sustain. Calls for speculation.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection. Mischaracterization of testimony.
Overruled.
Yes, it was.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were, correct?
Objection. Speculative.
Overruled, the witness may answer.
Yes.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
Okay. You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection. Speculative.
Overruled.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection. Speculative.
Overruled.
You said
And
that.
mischaracterizes the testimony because that was not testified to before on direct.
Oh, your objections are overruled. I believe the witness already answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it.
you?
No.
Okay, just wondered. Mr. Lescano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You and her ever talk about this case through your testimony?
Objection. Hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection. Hearsay.
Overruled.
No.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
You stated that you saw the driver, correct? Of the SUV that you saw that day, correct?
Yes.
And how did the driver look that day you saw him?
He had a scruffy beard and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance, tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast down that street. I wasn't paying attention to the color clothes you were wearing. I knew it was a black male and had a scruffy beard. First thing I told my wife is he was a black guy driving.
I'm going to switch it over to this other clips. I think the other clips are better.
The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Opper, Leslie Basie, and Zach Witchow, appearing for the state of Wisconsin.
Good morning, Your Honor. My name is Darrell Brooks Jr. My name is Darrell Brooks Jr. Say my name. Darrell Brooks Jr. I'm in the say my name. Darrell Brooks Jr. it is by special appearance, and I would like to ask, if it pleases the court, that someone can please render the account for me at this time.
All right, thank you. Be seated.
Extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it, extremely.
I'll answer yes if that helps.
All right, and then anything from you, sir?
In regards to this,
Any other preliminary matters that you are asking the court to address?
Were my filings actually filed? I don't understand the proceedings.
and I think that should be stated for the record. If I'm telling you repeatedly, Your Honor, that I don't understand, you can't force me to understand. I'm curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question.
Just for the record, Your Honor, I would like the record to reflect, is that a judicial determination that you are making?
All right, Mr. Brooks, do you have a 13th subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you you had until this morning to fill out another subpoena and give it to the state so that they could review it.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick. Mr. Brooks, I'm reviewing this for completeness. And you have simply put on here, state of Wisconsin plaintiff, that's an entity. You have to name a person, sir. All right, Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
I still hadn't even gone through the entire witness list from the prosecution. It's 30 plus pages. That's a lot of names.
Have you ever had any interactions with this entity, state of Wisconsin?
That's a violation of my constitutional rights to try to force something upon me. That's coercion, Your Honor.
Where'd you get this video from, sir?
Objection leading.
Overruled, the witness may answer.
From Mr. Brooks' social media account.
Okay.
The video wasn't even in the exhibits that I received. I actually didn't even receive it.
Mr. Brooks, please
Obtained.
stop.
Video is
The
ridiculous.
Darrell disregarded statements. He's not testifying.
Superstar.
I just, to be blunt, which I've been since the beginning of this trial, obviously, I see the whole strategy here by the prosecution. I see right through it.
If I have you stay in this courtroom, are you willing to follow the rules of decorum and courtesy?
I do not understand the question you are asking.
Do you have any other issues you want me to address?
Just very, very quick. I still don't understand the nature and cause of the charges against me, Your Honor, and I still would motion for, or tennis motion for the jurisdiction to be proven, subject matter jurisdiction. And also a motion for finding of fact.
Your requests are all noted for the record, and for the reasons previously stated on this record, I'm not going to answer those requests any further. They've already been denied. Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name. Yeah.
Noted. Do you have any questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That was a question.
Sustained as in the form of a question.
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
States directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
see nothing.
both parties to show
Come on, man,
decorum
this is not fair.
and restraint. I'm
So
not
is-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Are you willing to not interrupt the proceedings with disruptive behavior?
I do not understand the questions that you are asking.
Any other issues at this time?
Yes, I do. The statement of particulars that hasn't been responded to by affidavit. The notice of special appearance hasn't been
I
responded
direct
to.
your attention to the Barnaby decision, sir. The court's not going to be addressing that topic any further.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today? First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiriting remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful.
I believe you're choosing not to answer them,
You can
sir.
believe what you want to believe. I believe that you hiding stuff from the jury. I believe you haven't been impartial or fair. You haven't let me even enter anything into evidence, which is my right to do so. And to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
This is mine, Bible. This is mine.
Next question, please.
I'm done with questions, man.
All right, thank you.
This is mine. Bible.
Right.
Nope, I don't understand. Nope.
The jury deserves to know who the plaintiff is in this matter. I think it's fair to them if they're to make an informed and intelligent decision, they should know who the plaintiff is.
Do you think I would sit here and be this irritated?
Mr.
by
Brooks, I need to
something
make
that
a
I saw?
record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. You opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes. All right, we are back on the record. It is 1:01 p.m. State versus Brooks. Appearances are as they were before. I would note I have instructed, and Mr. Brooks is present in this courtroom. Prior to the, I understand your objections noted.
In this courtroom.
If you would like to go back to the other courtroom, sir, You may, but that is a choice that you would be making. I am not requiring you. I'm not forcing you at this time.
So you're not holding me in contempt?
Sir, I am not requiring you or forcing you to go into the other courtroom. Well, given that he won't answer the questions directly, for now, he is to remain in this courtroom.
I'm requesting to not be in this courtroom.
But you won't go through, you won't answer my questions regarding that, sir.
I did. I told you I don't understand.
That's not answering the question, sir.
You asked me a question, I answered it. I don't understand. How can I answer something that I do not understand, Your Honor? But it doesn't matter what we believe, Your Honor. I'm merely stating a request to not be present for these proceedings. I cannot answer the questions you are asking me because I don't understand them.
You understand your right to be present in the courtroom. Are you telling me you
I don't understand anything because I've been over there all morning.
To the place that you are requesting to go back to, right?
You sent me into the other courtroom.
You're right, I did.
Right. So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right.
But when I'm making a request to avoid the drama and all that.
Sir, the only one with the drama is you.
So let's
to the other
make the record
courtroom,
correct.
and we
I'm
have
the one
the
that asked when
audio
we came in here, Your Honor.
and video working appropriately.
I asked when we came in here to
Madam
be
Clerk,
present for
we'll
the
have
other
to do it
court.
by Zoom because we may have to utilize the share screen in order.
We don't have to utilize no share screen because I'm not going to participate in no proceedings that I don't understand.
Documents.
I told you I don't understand
We're
a
in
million
recess until
times.
we get the courtroom set up.
No, we don't have to be in recess. I don't agree to it. Yeah, would that be, will my objection to that be noted for the record?
It is.
Now I request a legal reconsideration of your ruling, Madam.
Denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied. Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. Well, I trust the state will object when appropriate, if appropriate.
It's gonna be a whole lot of objection then because I'm gonna tell the truth. Don't try to come with your slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to preserve the integrity.
You've been slick. You've
Right.
been slick. How's that law for
Sir,
law?
if you choose not to give one,
How's that law for law?
you didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead, change your incorrect record. Go ahead. You can't rush me to judgment, or you can't practice law from the bench and tell me when I can do something and when I can't.
Mr. Brooks, I actually can, under all of the rules of procedure. It is my job to make sure there's effective and efficient administration of this trial.
So then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth, that they have the power. They have the power to nullify laws. They don't agree
You
with.
are absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely no right to raise that. That is clear by the law.
I can raise what I want to raise.
It's clear to me you've done your
What
homework.
you talking about? I don't care what you're talking about. I'm gonna let them know that they can nullify any law they don't agree with.
It is a new part of the day. I thought it appropriate to have you brought here, and only if you forfeit your right by conduct will I put you back in the other room.
So you gonna address subject matter jurisdiction for the record, or are you gonna state it on the record?
Okay, then with that, Ms. Bruno.
Subject matter jurisdiction, Your Honor.
The court's declining to address that further. I stand by my written decision that was entered last week.
So we won't be proving it for the record?
I stand by my written decision that was entered last week, sir.
Judicial determination?
It is a judicial determination.
We would just like to make a record with regard to the concern Mr. Brooks had yesterday about the juror that he believed he recognized from his initial appearance that may have made some type of hand gesture to him.
The juror that you suspected was the woman who made an inappropriate gesture toward you at the initial appearance. They are not the same individuals. I've been able to confirm that. I know the identity of the woman who did what you said, and it is not this juror.
Is there any way that I can be sure of that?
I'm declining to address that on the record for the reasons I've previously provided to you, not the least of which is I have addressed that by way of a written decision.
And it hasn't been proven for the record. You
Your
have to state
objection is
on the record.
noted.
Can I go back in the other courtroom? Because I'm not going to do this with you. I'm not.
Mr. Brooks, I do want to go over
We don't have.
jury instructions.
I don't understand the
verdicts.
jury instructions. I don't understand anything that's in these proceedings, and I'm not going to participate in something that I don't understand.
That's your choice, sir.
May I please go back into the other courtroom?
So that's why I cut.
Hi, Brenda. Thank you so much for joining, honey. Welcome to the hee hee and the kiki. Okay. Okay, I'm going to go ahead and close it out here, you guys. I just put in the chat the link to the playlist of my Brooks coverage. If you guys want to watch that over there, you can. There were some marathons that we were just recently looking at, and that's where you're going to find the continued coverage or the continued play of what we were just watching. Thank you, Laura, and thank you, Bama, for modding for me today. I appreciate you guys so much. And thanks for being here with us. And just remember, we're all here together. If you have issues with your Brooksaholicism, just come and find one of us to talk to and we'll help you. Y'all be good, and I'll see y'all tomorrow.